House Bill 895. Delegate Holmberg, you may begin.
Go live here. Great. Okay. So for the record, Delegate Kevin Hornberger presenting today on HB 895. For some of the more veteran members, you'll know over the last decade, it seems like, we worked to sort out electricians, how they matriculate, their licensure, pathways to licensure. And this bill seeks to sort of part two of what we did with the Maryland Electricians Act. And before we get too far in the testimony here, I want to say that this bill is a starting point. It may not be the destination as written, but it is a starting point to make sure that we have appropriate, safe licensure with registration in the state of Maryland that deals with what we'll refer to, you'll hear different terms, low voltage, integrator, data, fire, limited energy, alarms, all of these things are under the umbrella, the auspice of low voltage. So the language in the bill does parrot some of the Electricians Act. If you look in your submitted testimony written, it's all across the spectrum, anywhere from support to oppose, amend, etc. But this is something that we promised the low voltage cohort that we would continue to work on after the electricians bill was passed. And other states have treated this differently. However, we want to be at the forefront and show leadership on this issue because this industry, in some estimations, is actually larger or is about to eclipse the traditional route for electricians. And the other thing to keep in mind here as well is that electricians will always preserve the ability to do this work as a master electrician. However, there are folks in this space that want to have licensure that do not want to go the master licensure route for electricians. So with all that background, I'm not going to get too far in because we do have a big board here to present. Don't want to take up too much time, so I can take questions now, or we can let the rest of the favorables. Yep. Okay. Whoever would like to go next, go ahead and grab a mic. Yep.
Sure. My name is Dave Cadieux. I'm the executive director of the Communications, Cable, and Connectivity Association. I reside in Frederick, Maryland. And just looking around this room, you see the cameras, you see the routers and the TVs and all that. Just so you know, that's what integrators do. That's what limited energy installers do. And it's a different discipline, it's a different training than electricians. And you know, we work together on the Maryland Electricians Bill, and I firmly believe that this bill, and once we get to the point of full legislation, it's going to be a perfect complement to the Electricians Bill. And again, you know, as Delegate Hornberger mentioned, this industry is growing very rapidly. You can imagine from your own homes and your offices how rapidly artificial intelligence and, you know, we're only on the beginnings of 5G, by the way. And all of that is part of this work. So we need to create some good licensure in the state of Maryland to manage that industry. They're unique in the examination. We're working on that part of the strategy as well through NASCLA. We're doing a lot of things to create the differentiation of integrators from electricians. So we support this initiative and this bill, and we'll work together with everyone to make it right.
Mr. Chairman, members of the committee, I'm Frank Boston III. I'm here today on behalf of Dish TV and Direct TV, and we support this bill. We thank Delegate Hornberger for putting it in. It's, as he has stated, it's been about a decade of working on this, and congratulations to Delegate Hornberger and Senator McCray for getting the electricians piece done. The purpose of this bill was really to be simple, to create a statewide license for low voltage installers and workers. Basically to say that if you work on class 2 and class 3 circuits, that you don't have to be an electrician. Local jurisdictions could still require permits and fees. We specifically tried to put in language that this bill would not touch life and safety work that is preserved for electricians. You know, the fire, burglary, alarms, systems, etc., like that. However, the bill as drafted is a bit confusing, and as the proponent of the bill, requesting the bill, we admit that. It incorporates us into the electrician's code. That was not our intention. I want to be on record as saying that. We wanted our own section of the code. And I thank the members of the Electricians Workers Union for meeting with us in advance of this hearing so that we could hear their concerns. And they do have valid concerns. If you read the bill, it looks like we're moving journeyman, the word journeyman around, the master electricians. It's like a rewrite, and that's not what we wanted. So we appreciate the concerns, but that's not our intent. Our intent is just straight-wide state licensing, and so that, you know, we can have a unified permit throughout the state, license throughout the state, and that we can make it, have a clear and bright line of that we can work on Class 2 and Class 3 work without being an electrician. Thank you.
Thank you, Chairman Wilson, Vice Chair Crosby, members of the committee. I'm a resident of Anne Arundel County. My name is Eric Davidson, and my business, American Automation and Communications, is headquartered in Bowie, Maryland. We employ 10 Maryland residents. I'm a member of CEDIA and the Consumer Technology Association, both national organizations that represent thousands of integrator members in the state of Maryland. My company and I hold various limited licenses in a number of jurisdictions. Obtaining and maintaining these licenses is an arduous and expensive process, especially for a small business like ours. It requires numerous exams and then in-service updates to stay current. It's a process which I can't delegate to any other employees. I have to do this all myself. So it takes a lot of my time from the actual business of selling and installing systems, whereas I could be hiring more people, but I'm focused on getting licenses. A statewide license would help to streamline the process, and in some cases might eliminate some of the currently required steps to obtain an electrical permit. This could result in increased productivity for integrators such as myself, lower administrative costs for local jurisdictions, and allow for uniform contractor requirements throughout the state. I ask that you support the bill, but with the one exception of requiring the same licenses for those providing or installing hardwired fire burglary and alarm systems, as the methods used and the adherence to National Electrical Code are the same as for the other low voltage systems. Thank you for your time.
Good afternoon, Delegate Wilson, rest of the committee. We are here to approve this bill as well, so we are pro for this bill. My name is William Foy, born and raised in Maryland, currently live in Harford County, spent many years in Cecil County and Baltimore itself. So I am an employee of a subsidiary of Clark Construction. The company is called S2N. We are basically a general contractor for limited energy systems. So we will design as well as install limited energy systems, low voltage systems, however you want to word it. So with what we do, we are basically designing and installing systems that are technology-based systems. The cable infrastructure that we put in place is basically telephone wire like this. So we put in these smaller wires, we put in the systems so that they are capable of supporting all the technology in the buildings. We do not do high voltage electrical work like was set up through the provisions in the original bill, which was for the electrical. The closest we get to utilizing electricity is when we plug our equipment in using regular electrical plugs like you do at your home for your toaster, your TV, your stereo. So we are all for this particular bill so that it is providing us with a statewide license for all of our low voltage subcontractors that we utilize, as opposed to having to get 26 different, jurisdictions to approve of a license. So we're full support of it, and anything we can do to help, we're here.
Yeah, I guess I'll just speak here. Good afternoon, everybody. Thank you for your time. My name is Wayne Harrison, and I own and operate a limited energy, low voltage company. We've been in business for 25 years. Just going to kind of reiterate what you've heard already. I want to thank Delegate Hornberger again for his efforts for bringing this bill up. And I basically have currently hold 16 low-voltage licenses in the state of Maryland. It is very arduous to continue to keep track of when they're due, when they're up, paying the fees, being tested continuously 10 hours of CEUs every year for certain counties, but not for other counties. It becomes very convoluted and confusing. So, you know, I'm in approval of this bill to get a statewide limited energy license. And some of the bullet points I'd just like to bring up, in addition to what everybody else said, it is Class 2 and Class 3 wiring, which is what you see in here, cameras, communication, telephones, that kind of stuff in the past. But what we do basically causes is no danger to shock or electrocution or any of that. And so it doesn't take away work from the electrician. We actually work with them. They can do what we can do, but we can't do what they do under our license. And we just respectfully request a statewide license to simplify the process. Thank you.
Thank you. I believe that concludes the favorables. I have two questions. Delegate Hidalgo.
Thank you, Mr. Chair. And just so I understand, because it seems pretty simple, you're just looking for a statewide license as opposed to individual jurisdictions. As far as low voltage is concerned, you're talking about cameras, Ethernet cable, like Cat5, Cat5e kind of cabling, smoke detectors, cameras, that kind of thing.
Spot on.
Yeah, that's, and that does sound like, I appreciate you simplifying it. However, the difficult part here, and why we have this bill, and probably might have to move this to potentially a study, is where do you draw the line, right? Because there is overlap. If you look at audio, for example, audio engineering,
Right.
Voltages can spike up into the 90, 120, you know, where you're now crossing over into traditional electrician work. So that's why we're going to lean on the wisdom of the crowd here with this committee to help us craft this language. So that these guys don't have to have all these licenses and they can focus on the work. So yes, that is a simplification. That's all we're looking to do, and we appreciate all your help.
It's the question of where that line is from going from low voltage,
Yeah.
USB or something like that to
Yeah,
something.
and you're going to hear from IBEW and the other folks that come up next. They want sort of the same thing. They just don't want someone in this cohort working on life safety stuff, working on high voltage, or and they're very concerned about bad actors getting this license and then trying to do work that they shouldn't. So those are the things that we need to consider when we're crafting this.
Valid concerns. Thank you.
Yep.
Delegate Chi.
Thank you, Mr. Chair, and thank you for the panel. I can understand your argument, but I also know that counties can only go up in terms of the level of regulation based on the state regulation, right? So I understand your argument for one unified kind of license. It streamlines and reduces the cost of doing business and all of that. But my concern is I've scanned through some letters, opposition letters. How do you respond to the concern that this would actually lower the standard? Because counties usually go more stricter when it comes to regulation than the state level, right? So would that be an element of concern that they will lose some expertise of people who are trained in those areas to do certain work in certain counties? And on that front, I was looking for MACO's letter. I didn't find one. Does MACO have a position on that?
No, MACO hasn't weighed in on this. They obviously did weigh in on the electrician's bill as we got towards the tail end, the last few years. So we're just seeking to do the same thing that we did with the electrician's bill with this. And to your question about additional above and beyond, these are industry players. They're completely fine with above and beyond. They just want a standard across the board so they can get one license. So if a certain jurisdiction, for example, or Baltimore City would like to say that, we need additional certification or additional license, that's fine. But these guys are having to just do a managerial nightmare of keeping all of these licenses, approved and the CEUs and renewed and the checks and all that. So what you just alluded to is happening with the electricians world already, right? So they can go and get their permit, they can do the work in any jurisdiction, and by having a statewide licensure, the added benefit that we haven't even talked about yet is the ability to go cross-jurisdictional. So once Maryland moves into a standardized license, it allows all of these guys to have reciprocity agreements with DC, Virginia, Pennsylvania, and allows them to expand their business. And then it's all based on, you know, industry standard. And once we get that license squared away, they can go into these other jurisdictions. So very valid question. Thank you.
Thank you. Seeing no more questions from this panel, you guys are excused. We'll be calling up the unfavorables now. Balfoy Albuquerques, Tom Clark, Kevin O'Keefe, Grant Schmelzer.
Mr. Chairman, committee members, my name is Grant Schmelzer. I'm the CEO of the Independent Electrical Contractors Association. We are based in Laurel, Maryland. I reside in Montgomery County, Maryland. IEC Chesapeake is the largest four-year apprenticeship program in the state of Maryland with over 1,000 apprentices. Additionally, we have a low-voltage apprenticeship program, which is the largest in the state across all of the apprenticeship sponsors. Our members are comprised of over 170 different companies that employ 10,000 electrical workers across the region. I'm here to testify in opposition of the bill. I'm going to give some high-level highlights as it relates to apprenticeship and turn it over to my colleagues from the IBEW to get into the technical side of it. I want to note that having both the merit shop and union side here testifying in opposition is an anomaly besides the electricians bill. And we really came together to push that through along with our friends on the low voltage side. My biggest concern in the legislation is that there's no identification of what an apprenticeship program looks like. It references apprenticeship. It's not identified inside the bill. As a member of the State Apprenticeship Council, underneath the last four governors, even though I'm not testifying on behalf of the Apprenticeship Council, I see very different types of apprenticeship programs that come before the council. And that's part of the challenge when Delegate Hornberger mentioned there's lots of different factions within the industry, and that's something that's going to be need to addressed in this legislation. Also, additionally, we talked to the journey worker ratio that's referenced. We're going to have to address that issue. So we are committed to getting this over the finish line, but it's just not there. Thank you.
Good afternoon. My name is Tom Clark. I'm with IBW Local 26. I oppose 895. To be honest with you, Mr. Baltzen said it was a bit confusing. It's kind of a rewrite. This is the Electricians Act. They just scratched it out and put some low voltage language in there. Not even language, their name. So there is no bill here. Let's get that straight. In fact, on page 6, you'll see, like they said, it's got nothing to do with electricians, but it's got our name all over it. Apprentice electrician, journey person electrician, master electrician. So I would just like to have a bill here that we can look at and work out. You mentioned smoke detectors. Smoke detectors are life safety, so that shouldn't be there. But a lot of control work can control high voltage, and that's when you get yourself in trouble. These lights above your head are 277 volts. 277 volts has a tendency to grab you, where 480 would just knock you through the wall. 120, any volts, it can kill you. But the point is, if you control it by low voltage, and there's 277 volts in there, an electrician should be doing that. So I would just like for an unfavorable vote on 895, and I appreciate your time.
Thank you, Chairman Wilson, members of the committee. My name is Kevin O'Keefe. I'm also here on behalf of the Independent Electrical Contractors Chesapeake. And I just want to emphasize that we tried, as you all know, for about 10 years it took us to get the statewide journey person electrician license. So at this point in time, we think the best course of action would be to create a work group or study group, however you want to phrase it, where we can sit down and work together. And I hopefully promise it won't take 10 years. Thanks.
Thank you.
Hello, Chairman Wilson, committee members. Thank you for the opportunity to come speak to you today. My name is Rico Albuquerque. I represent IBEW Local 24 in Baltimore. I don't have anything of substance to add to what these gentlemen said, so I'm going to save you guys some time and echo their sentiments. Just looking for an unfavorable vote. Thank you very much.
Appreciate that. Seeing no questions, thank you guys very much. That does conclude this bill hearing. Next, we have House Bill 335, Delegate Hill. And Delegate, do you have a panel?
Yes.
Can you invite your panel up as well? They can introduce
All right.
themselves when they begin speaking.
Okay, so I've got, let me see here, I think James Lanier and Matt Pavlo and Robert Phillips. And Pat Savage. Good afternoon, Mr. Chair and committee members. I see the Vice Chair is off probably delivering his own thing. He's gallivanting, okay. All right, let it be known. For the record, my name is Terry Hill, and I'm here to present HB 335, Workers' Compensation, Occupational Diseases and Presumptions. In addition to my written testimony, I think all of the members have received a couple of articles that talk about PTSD, 911 operators, and how significant this behavioral health condition is. So, you know, we all know the sound of it, right? 911, what's your emergency, right? And we benefit from having highly trained professionals answer our cries for help. We know that those calls can be harrowing, that there's traumatic incidents that require these trained professionals to be on the phone for minutes and even close to hours while they talk people through very trying circumstances and negotiate to get other first responders to arrive on the scene to resolve the situation. There can be violence, there can be death, there can be all kinds of other truly traumatic things, and we expect these people to be unemotional and calm and to handle their business professionally. At the same time, most of us talk about how our world is getting so out of control. The news has all kinds of things that can really be upsetting. We usually can manage that. We can turn off the dial, we can change the channel. There are kinds of scenes that I'll hear about, but I won't even bother to watch on television. And there are stations that report news that I don't want to hear anymore. 911 operators don't get to do that. They don't get to do that. And because when we talk about post-traumatic stress syndrome, it generally requires that there be some triggering event, that there be something that the person saw that was somehow out of line with their routine stuff. It makes it very hard for these first responders to get the support that they need to keep themselves as healthy as they need to be to do the job that we ask them to do. So 911 first responders not only need to be acknowledged as people who suffer from PTSD, as the studies show, between 18 and 24%. But we also have to recognize that they're not going to have single triggering events. They're going to have cumulative traumatic exposures that are often unresolved. And the manifestations are going to show up like they do for many of us when they're under stress. We might see some hypertension. We might see some loss of sleep. We might see some heart disease. We might see some suicidal ideation, or we might see people who just quit the job. This seems to be one of the reasons that we have such a hard time keeping those jobs filled. The work of the Next Generation 911 Commission was to expand the new generation 911 uniformly across Maryland to make sure that our systems work optimally to keep our communities safe. One of the recommendations of that group was that 911 specialists should have a presumption for PTSD. And when that bill was presented before this committee last year, one of the questions that was asked was, what other first responders get this? Do police officers? Do firefighters? Well, if they don't get it, why should 911 operators? And we took that back and thought about it. And you said, that's an excellent question, Mr. Chair, and you're damn right. Our police officers who get presumption for hypertension and heart disease without our paying attention to the underlying stress that causes hypertension and heart disease, they deserve presumption too. And our firefighters who have a list of carcinogenic exposures that allow them to get presumption for physical ailments and for the physical damage that they do to their bodies, they get presumption for that, but they don't get presumption for post-traumatic stress either. So we're bringing the bill back to you, asking you to do right by all of our first responders and give them the presumption for post-traumatic stress syndrome, because the jobs that they do are the things that create the most significant stress over and over and over and over again. We know it. They know it. So that's what this bill is about, and I'm going to let my panelists speak to the merits. But let me just say that if we deal with the underlying causes, we may find we save money overall by decreasing turnover, by treating people for their underlying diseases. So perhaps we spend less money on the hypertension, the heart disease, the diabetes, and all the other things, the sleep disorders that often make them not perform their jobs the way we want. We're doing a lot of oversight on how they perform. Maybe if we gave them the support they need to do their jobs well, we'd have less issues with performance. We put parameters on this, minimum amount of time they have to work, a maximum amount of time that they get coverage, because for, generally speaking, 8 months of treatment is considered the average treatment for PTSD. And we put, and the amount of time that they can be separated for the job where that presumption would still hold, because we understand that there is money involved and that that's important for the state too. But we owe these people something for all that we continually ask them to put themselves to. Thank you.
Thank you. Good afternoon, Mr. Chairman and members of the Economic Matters Committee. My name is Jim Lanier, and I'm here on behalf of the Maryland Association for Justice. The MAJ is here in support of this House Bill 335 and asks for a favorable report on the bill. I can't really speak much more eloquently than the delegate did, but to add to what Delegate Hill said, she mentioned the firefighters and the cops and the 911 specialists, but the other leg of the chair that is also included in this bill that is also very important is the correctional officers. They're the first responders, but not really first responders, but they have to deal with all of the things that the first responders deal with on the back end. they're the ones that we don't see day to day because they're the ones down in Jessup or in Hagerstown or Cumberland or Westover who have to deal with all of the high criminal aspects, and they also have the same mental stressors in the same type of way that the regular first responders that we think of in the public. So in including the correctional officers, the MAJ is very much in support of not leaving them out as well, and recognizing that the same problems that affect, an EMT also affect a correctional officer. If there is one, with all due respect to this delegate, if there's one aspect of the bill that we have a slight pushback on is that if it did come in with the 18 months for medical care, this would be the only part of the Workers' Compensation Act that limited medical care. So if there's anything to consider, it's whether or not there should be any, because if you have a quote-unquote a regular compensable, and that's our terminology for a good claim that's entitled to benefits, they get lifetime medical care for anything that is necessary, reasonable, and related. This would be the only circumstance in which someone would have a limit on their medical care. So with that slight information, we ask for a favorable finding of the bill. Thank you very much.
Thank you. Matt Pavel, also with the Maryland Association of Justice. Mr. Lanier just gave some of the specific items that control this, and when you look at it, it's very controlled. This can't be overstated or abused. There are limitations, both as he indicated, the 18-month of treatment. Of course, the persons rendering this diagnosis are supposed to must be qualified, and the person, the injured worker, must have already been on the job at least 2 years. So it's very controlled. The only other thing I was going to say is try to add some flair about how first responders are running to the hazard while the rest of us are running the other way. But I would do an injustice to what Delegate Hill just did. Well, she gave a full flavor. That was very dramatic and compelling, and there's nothing more to add in terms of drama than what she gave us here.
Good afternoon, Mr. Chair, members of the committee. My name is Bob Phillips. I am the legislative chair for the Maryland State Firefighters Association. We are in support of this bill, favorable with amendments. You should have my written testimony. If you read it, it's just letters on a piece of paper. I want to try to make it real for you. I apologize if I get a little upset. My wife, Bonnie, she was a 911, what they call specialist today. She preferred dispatcher, 17 years. We've been together for several years, and I could see a difference in her about 2012. In her mannerisms, the way she acted, the way she interacted with other people. You have to understand, this woman was the life of the party. She worked hard, she believed in what she did, she lived it. Then she started pulling back from anything and everything. We were always out. We had a pretty active social life. But she got to the point that she would not want to be around other people. I asked her to go see a doctor as I felt she was having some serious emotional issues. Took a while. February 25th, 2017, 5 years later, she walked in the house after a 12-hour shift, sat in the middle of our living room, and just cried. She was done. That went on for about an hour. February 25th, she used up every day of vacation time, all of her sick time, because she was too proud to say she couldn't handle it. She finally went and saw a professional. She started getting help, and she did eventually file a claim. And thankfully, I'll be honest about it, it took a lot of effort on behalf of the gentleman that was representing her, but the claim was found. I'm sorry?
He said, go ahead.
Thank you. I appreciate that. The claim was found in her favor. The treatments continued on a weekly, monthly basis until 2022, 5 years later. That's 10 years now, and she's had this problem. The sad part is she didn't live long enough to see treatment ended. That's the sad part. I'm talking about a woman that was the life of the party. She became a total recluse. She wouldn't sit on her front porch, which she loved to do, and watch the sunset, because she was afraid someone would stop to talk. Members of this committee, PTSD does not have a date stamp. And I feel that the amendment to this bill is a good bill, but to limit the treatment to the 2 years that was in the one I read, I think is a tragedy. Now, the gentleman on the other end of the table here, they have all the statistics. They know all the facts. I don't know those, but I know what happened to my wife. Thank you very much. I appreciate it.
Thank you very much, sir. I have a few questions before we move on. So to be clear, you're obviously not precluded from claiming post-traumatic stress disorder, correct?
No, sir. You can file a claim for it, yes.
Thank you. And I say this because I guess post-traumatic stress disorder in many ways is almost like soft tissue damage. It's very hard to disprove unless and I say this, I take 300 milligrams of trazodone a day. Okay, so I'm not saying this because I don't know what the hell I'm talking about. I'm saying from a legal point of view that what has been explained to me is it's difficult at times to prove or disprove, more to the point, mental injuries such as post-traumatic stress disorder, which is why I thought the cap was put on there to try to create some balance.
Well, anytime you have a situation where someone has a pre-existing medical condition, that's always considered whenever you're filing a claim. So, for example,
I don't think that was my question.
I'm sorry, sir.
I wasn't talking about pre-existing medical condition. I'm talking about the difficulty in disproving someone's claim of post-traumatic stress disorder.
Well, that's the power of the presumption in which the burden then would shift. We still have to have the prima facie case where you have a medical provider indicating that the diagnosis, the treatment plan, and the causal connection.
Correct.
But you're correct that it would then shift the burden to the employer to then show that it was not related, but then the employer would be able to go back into that person's medical history, and if they were on trazodone for an unrelated mental health struggle or some other medication prior to their employment, that would be a defense that they could bring to rebut the presumption at the commission.
Because I was just trying to understand the limits, and I thought that was like more of a mea culpa thing to try to come together, because it is, and again, you misunderstood what I was saying, it's very difficult to disprove things like lower back injury or soft tissue damage when you put in a claim. I'm a plaintiff's attorney, so I do know this. And post-traumatic stress disorder, again, is one of those things that could be very difficult to disprove. And there was a caution on individuals claiming this, and again, mine's through the military, and they are somewhat rigorous on our claims when we lay these out, especially 20 years ago. So I was just trying to understand, because that's where I thought the 18 months came in as more of a middle ground for treatment. Now I'm hearing now that nobody wants this 18 months.
Well, the concern that we have is that if you, like taking your example here, sir, is that if you just had a regular post-traumatic stress case, for example, I had one recently where the shop owner was held up at gunpoint. It was an armed robbery. So it was it was a physical mental claim, what we call it. Physical act caused a mental injury. Now that individual would not be subject to any sort of limit on the need for medical care. They could go for a week, a day, a month, for the rest of their life, God forbid, if they need it for that long. So there's always going to be the requirement on the claimant's part, the injured worker's part, to prove that whatever medical care they want is related to the work injury itself. All this does is get your foot in the door so that you're entitled to benefits easier. It doesn't make it so you get everything for the rest of your life as presumptive. You still have to go in after the case is compensable to prove the entitlement to whatever benefits you're seeking, including medical.
I mean, and again, I do understand, but to be clear, the way you're asking is that if I claim post-traumatic stress disorder, and I so happen to be a member of these these first responders, it's presumed that I got it as a job, as working the phones or being a police officer, and that's what you're asking.
Correct.
Okay.
Thank you, Mr. Chair. I want to thank the sponsor for this bill. As I was listening to your testimony, I recall speaking to a constituent in my district about a year ago who was a 911 dispatcher. And so we had a conversation, and I asked her to kind of send me an email so that I could follow up. I wanted to address some of her issues at the county level, but I figured if I read some of this email, it kind of applies to this as well. And it says, "Hello, Mr. Jackson. I just wanted to say it was a pleasure meeting you, and please keep your promise about speaking up for the 911 center. No one really advocates for us. It's like we're the forgotten ones. No one can relate to the amount of stress we deal with on a daily basis as operators and dispatchers. As I stated to you, the public think of us as glorified secretaries. However, our career entails so much more. I would love if you and your constituents could visit the center to see what we really do on a daily basis." And so I just kind of wanted to read that. I mean, this was sent about a year ago. So that kind of shores up what you're saying about the amount of stress that some of these 911 center operators go through. So I just kind of wanted to put that on the record. So,
Thank you.
thank you.
Isn't that so?
Isn't that so?
Please.
Yes.
We're asking
And
questions.
thank you,
very much.
Mr. Delegate Jackson, to your point, you're correct. And to the chair's point, we put the 18-month on here as a way to try and get this bill to move. I don't think that is appropriate, but if we can't get it without those parameters, I'd rather have them have something than nothing.
Thank you.
Thank you, Mr. Chair. Thank you, Delegate, for the bill. I certainly do appreciate this. This is a subject matter that I'm quite familiar with. And a couple of questions I had have now been answered because the chair did those responses. But in looking at testimony from Chesapeake Employers Insurance and as well as MACO, they're both in opposition. Have you had a chance to talk to them and see where they are in their process and what distinctively makes them oppose this piece of legislation, given a lot of the counties are having first responders, et cetera, employed?
Correct, right. So I have not had a chance to discuss it with them, but my understanding is they're concerned about the financial piece. The other information that we had from them was that for firefighters and police officers, even without presumption, 100% of the cases that are brought are found for the first responders. If that's the case, right, then they're already getting presumption without having to go, but they're having to go through loops to get there, right? So they have a way to advocate. I don't think giving them presumption changes that. I think it makes it easier for them to get the care that we actually want them to get, right? The 911 operators are different because with firefighters and first responders, that burden of identifying a triggering event, or as we say, that it's a physical something that you were present for, that is easy to point out for the kinds of, not all of the stresses, but many of the activities that they're involved with on the job. But again, there is an inherent bias that if you're not there, you're not experiencing the stress. And that is, in fact, from a medical standpoint, almost the exact opposite. To hear it and not be able to see it, to not be able to get the closure, to not be able to do anything but listen to the child tell you that their mother's dying, right? To hear the gunshot go off while you're trying to talk someone down, to get no closure is part of what builds on the cumulative stress. So my presumption in looking at what we've seen some other places is that we're not going to see a huge increase from firefighters and police officers. We may see some, and if we're seeing that that's good, it means that we're actually helping people to acknowledge behavioral health as real and important and encouraging them to take care of themselves, but it will make a difference for this very specific group of people.
Thank you, Delegate. And with regards to the financial part, I saw we're estimated about $29,000 per case that has been brought forth to Chesapeake employers. But if there's something higher than that, if you could just let the committee know, that would be great. I'm just
Certainly.
trying to
And
understand.
it may well be that if we get treatment earlier, it would be less expensive.
Sure. Thank you. Thank you, Mr. Chair.
Thank you. I have one last question. How many other states are currently using this model that you're trying to lay out here?
They say none. I thought I had found two, but I'm going to get some facts and get that back to you. All right?
Thank you very much. All right, guys, I believe there's nothing else for this panel. You guys are excused. We're going to the unfavorables. Lindsay Miniger, Carmine D'Alessandro, Ashley Smith, and Brianna January. Okay, I believe Brianna is virtual, so we'll get to her after you guys. Go ahead. You may begin, sir.
Thank you. Good afternoon, Mr. Chair and members of the committee. My name is Carmine D'Alessandro. I am Chief Legal Officer for Chesapeake Employers Insurance Company. We insure about 20% of the market in Maryland for workers' compensation. We also insure 9 counties and about 150 municipalities. I also serve as the president of the Injured Workers Insurance Fund. The Injured Workers Insurance Fund is the third-party administrator for the state's workers' compensation program, about 80,000 employees that we also administer. I'm here to respectfully oppose House Bill 335. And first, as Chair Wilson alluded to, post-traumatic stress disorder is a recognized area of law that's recognized in workers' compensation as a compensable event that you can have as either an accident or a disease. Maryland was actually in the forefront. We've been operating on this law for about 40 years, and when Ms. Manager speaks, she will talk about the case law that established this law in Maryland. As you see from my written testimony, in the last 5 years, we currently have, between IWIF and Chesapeake, 281 open claims for post-traumatic stress disorder. As you've heard from the prior panel, the benefits that those individuals get currently are actually more than this bill would allow. They get lifetime medical treatment, they get indemnity benefits. It's not 100%. Delegate Hill said there were 100% success rate. No, we do contest some. We've contested about 20 in the last 5 years on various grounds, some procedural. But I want to hit on why we don't think a presumption is needed. And I want to talk about the cancer presumption. The reason we have a cancer presumption is a firefighter is never going to be able to show that the lung cancer is from fighting fires and not cigarette smoke for 20 years. So we give that individual a head start evidentiary. In post-traumatic stress, in the work-related area, there's always an event. And because there's an event, we can tie it back to that event, and that's why we've never needed a presumption. It's a lot different from trying to prove or disprove how you got your cancer. Because it's in the work area, there's an event, and that's why we've been able to adjudicate these cases without a presumption. Thank you, Mr. Chair.
Thank you. Next.
Good afternoon. My name is Lindsay Beidel-Menninger. I am the Vice President of Legal Services at Chesapeake and the Injured Workers Insurance Fund. To answer Chair Wilson's question earlier, other states do have PTSD presumption statutes, mainly because it was not compensable via case law, and so those statutes were created to fix that issue. We do not have that issue. We have 2 case laws from the 1990s. The first being Means versus Baltimore County. Ms. Means was a paramedic. She saw several devastating accidents over her time as a paramedic. She was diagnosed with PTSD, and that claim was found compensable as an occupational disease. The other case, an accidental injury with Belcher v. T. Rowe Price. Ms. Belcher was sitting in her high-rise office. A beam came through the window. Wires were down. She was trapped at her desk. The lights were out. She was very scared. Now you have an accidental injury PTSD claim. So both are compensable. We act accordingly. And that is very important to point out because we've already taken care of our people for the lifetime of their PTSD diagnosis.
Hello, my name is Ashley Smith. I'm here today on behalf of the Maryland Defense Council. I would just like to build slightly on what Mr. D'Alessandro and Ms. Manager indicated, and that's that, post-traumatic stress disorder, the trauma is in the name of the disorder. when you go to the doctor and what you are getting therapy for and what you are being treated for, that's the subject of your sessions. It's helping you work through that trauma. And so we know, just based on what you're talking to the doctor about, what the root of your problem is. If you're going to the doctor and you're saying, I was abused as a child, or I was in war several years ago and I haven't recovered from the horrible things I saw in wartime, that is going to be what your PTSD is related to. But this bill says that people who have traumas like those, if they happen to be employed by you as a firefighter or a first responder, are going to get benefits from the state and local government or from the insurance company because of the PTSD that is completely unrelated to their employment. And as Mr. D'Alessandro and Ms. Menninger indicated, it is fully compensable if the trauma is tied to your employment, whether it be from a single horrific trauma or from like a 911 operator or for a firefighter encountering multiple traumas over the course of many years. That would be compensable. And we would just emphasize that this bill actually hurts first responders by limiting their ability to collect benefits for it, as opposed to now they can get lifetime benefits. And for that reason, we would say that we would request an unfavorable report.
I would just ask, when you say limiting their ability, is that because of the 18 months?
Yes, that would be because of the limitation on medical treatment.
Because you do know that pretty much the proponents of the bill don't want that either. I hope that's not, yeah. I don't think that was the goal of the bill. That was what I was trying to get for Delegate Hill understanding. She's trying to get a workaround. You guys are kind of selling the same boat here, accidentally maybe. But without that, do you think that it would be detrimental to these workers, this bill in its current form, without that amendment?
Without those limitations that you've put in there, I don't think that it would be as problematic, but it would create other problems.
And that's what I would ask you to discuss, only because, again, it's the policy of the bill that's important. This body will, in its own, way, decide, what we believe how it looks best. But the policy of this bill was, are we going to recognize post-traumatic stress disorder as a presumptive injury? And I mean, you did address that, but you guys throw in the part about that 18 months. I don't think they want it there either, so I wouldn't lean too heavily on that. I guess we do have questions. Delegate Harrison.
Thank you. So, a worker who, a 911 operator who you say can be compensated for their PTSD, their occupational disease, are they limited now in what they can?
No.
No, ma'am. They would be treated like any other covered employee under the Act. So if you hurt your back, unless you settle your claim, you have lifetime medical treatment for your back as long as it keeps tying back to the injury. So a 911 operator who is receiving medication for post-traumatic stress that we've accepted, as long as he or she would need that medication, as long as they don't settle and close their case, they would have that medication for the life of their claim or their lifetime.
So your argument is that you don't want to presume that that's where their PTSD comes from. I'm trying to make sure that I'm understanding.
Okay, so to speak to what, Delegate Wilson was saying, even though I'm on the insurance side, I've been there for 30 years, I can't support a limitation on medical treatment. Everyone in the Act receives a lifetime medical treatment, so I'm in full agreement with the proponents who took issue with that. We've never had that, so this would be a complete outlier. I'm more concerned about the presumptive effect.
That's what I'm asking
that's what I'm sitting here for.
That's what I'm asking about. I don't understand what the argument is with the presumption.
The presumption, Maryland has one of the strictest presumption laws in the country. I think only Arizona is more strict. So even though we call it a rebuttable presumption, it's next to irrebuttable. So once you file a claim and you have a presumption, odds are that you're going to win that claim. So what happens is claims that otherwise would not have been work-related come in through the back door with the presumption. We just want to stick to the current case law that says anyone, not just first responders, non-first responders, teachers, grocery clerks, whoever has one of these events can go to the commission and prove his or her case and then be entitled to the benefits. So basically, we're relying on current law saying that a presumption is not necessary. In fact, last year, of all the 911 operators that testified, every single one had won their case. So there's not a situation where people are being barred from the courthouse doors to get in. So that's, we believe the current law actually covers what is needed now.
Thank you.
Thank you, Chair. And before I ask the question, Bob Phillips is a friend of mine. I'll see him Saturday at the, I think, the fire hall, and we appreciated the testimony that you gave us. This is just a probing question. You know, the rebuttable presumption, from my perspective, because it's in labor law and I had experienced this, is basically saying that that you have the right to go to court and prove that that's wrong, right? But it's like proving a negative in a court of law. Like you're already presumed to have what, in this case, it's going to be to have PTSD be the reason for the compensable damage, and then you have a right to challenge that, but you have to prove the negative. You have to prove against that, and the legal precedent there is what makes it nearly impossible to overcome, because in a court of law that becomes, it's an impossible feat. That's the testimony you're giving. So whether or not I vote for the bill or against the bill, I think what I'm hearing you say is that a rebuttable presumption is tantamount to, once the claim is made, you'll get the
Correct.
adjudication.
In most states, and I think 47 states, a rebuttable presumption, a firefighter comes in and says, I have lung cancer related to my job. And then when the defense says, well, wait a minute, you smoked for 20 years and you have a family history, the presumption sort of bursts. And now it's sort of, for lack of a better, even Steven. So the presumption was there until the evidence came in. In Maryland, even though you have that counterweight of evidence, the judge will still say the presumption still holds. So we actually have an extra burden in Maryland that most states don't, where that proving the negative carries throughout the entire case. It's never, excuse me, it's never shifted. So that's, yes, so basically I'm saying it's next to impossible in our current system. Right.
Seeing no further, I apologize. Delegate Queen.
Thank you, Mr. Chairman. So I just wanted to get some clarifying questions, because I think you started on it from Delegate Harrison's questions. So you don't want the presumptions because you say in Maryland we have case law that helps people, I guess, when they make these sorts of claims, get the relief they need or get decided in their favor. And you made a comment that, because my thought is we would need this bill because it's difficult, and made it seem like the testimony we heard that it's difficult for people to do this. So I guess I want to get a sense of, you know, how difficult is that? You said everyone who did from the 911 callers have gotten relief. Do we have numbers on that? How many people are getting the numbers that are filing and the numbers that are being, you know, denied, or the ones that are being, yeah. Okay, give me those numbers.
So we have 281 in IWIF and Chesapeake from 2018 to 2022. 173 of those were those first responders, the list of people on this bill. Of those, only 22 were contested. 21 of those were contested for procedural reasons. You're talking statute of limitations, last injurious exposure, which employer was on the hook, and or they've already had a compensable PTSD claim and we're going to put that new claim on the old claim. Only one of those cases of the 173 were contested on grounds because of what was in the medical records, and we lost at the commission. So there are your numbers for Chesapeake and IWIF.
So give me, what is that as the percentage of people that work for us
for
in those fields?
So 173, you mean the percentage of
Yeah,
which
because
ones were
it's
first
173, 1%, 2% of people who are, you know, 911 operators, or
I can follow up with that. I
because
have it in my
that,
data.
you know, that could be, what that number alone doesn't really mean much if I'm talking about 30% of my folks are having this problem, and you've helped only 2%.
And it's difficult for us with the counties. We insure 9 counties, so and most 911 operators are affiliated with the county, so that would be I could reach out to make.
So you understand why we want a statewide director,
we'll
right?
try to get ours, but
Yeah.
I'm going to have to reach out to Mako to get the other.
Okay, so until we get something better, it seems like I need this bill.
I believe that is all the questions for this panel. We have one more person unfavorable, but they are virtual. Are they on? Brianna, January.
Good afternoon, Mr. Chair, Mr. Vice Chair, esteemed committee. Brianna January representing MACO in respectful opposition to HB 335. Counties appreciate the goals of this bill, and we strongly agree that we need to prioritize the mental health of our first responders. And we would like to personally thank the folks who serve in emergency response and those especially who shared their stories today. You do difficult work, important work, and we sincerely appreciate your service. Counties do share many of the same technical concerns that the chair highlighted and that the witnesses before me have explained. I would just like to highlight one additional concern specific to counties as providers of emergency services. The reality, committee, is that with more folks seeking leave under HB 335, Marylanders, our mutual constituents, may experience longer wait times and insufficient responses to a whole variety of emergencies. This poses a personnel and a safety concern. These are, for the most part, positions that must be covered 24/7 to respond to emergencies. And we simply cannot have empty seats at 911 call centers or fewer folks responding to a fire, for example. Again, counties strongly share the same issues with the technical concerns expressed by Chesapeake, and we'd be happy to work on this bill and other measures. But for these reasons, MACO respectfully urges an unfavorable report. Thank you.
Delegate Sample Hughes.
Well, thank you, Mr. Chair. And to the witness representing MACO, forgive me, I can't see your last name, but my question is, so MACO is in opposition. Is it just mainly the 9 counties that have Chesapeake Employers Insurance, or are you saying that's all of our jurisdictions in the state of Maryland?
Thank you so much for that question, Delegate. It's a great one. All 24 counties are united in their concerns with this bill in particular. As you know, most counties do have large first responder personnel and staffing, but at the same time, we're really struggling right now to hire in all areas, whether it be firefighting, police, even at our call centers. And so the concerns, especially with personnel and with financial concerns, are expressed by all 24 here.
So it's more of a financial concern, is that correct?
Financial and personnel, yes.
Okay. Thank you. Thank you, Mr. Chair.
Thank you, and I believe that does conclude this hearing. Thank you very much, ma'am. Move on to the next hearing. Delegate Valderrama, House Bill 1012.
I'm wrong.
Thank you, Mr. Chairman, Mr. Vice Chair, esteemed members of the Economic Matters Committee. For the record, Chris Valderrama here to present House Bill 1012, Workers' Compensation Fees for Service. For the new members, this is not a new bill to the committee and very common to the incumbents here on the committee. My testimony will be brief, given I've given it for the last, I lost track how many years now, but do believe in this bill. It's simple and straightforward. It makes it easier. What it does is to make it easier for workers' comp complaints who have been denied workers' compensation benefits for medical treatment only to hire an attorney to represent them at an appeal before the Workers' Compensation Commission. If the appeal is successful, and I emphasize only if it is successful, this legislation seeks to authorize the commissioner to pay up to, not $2,000, but up to dollars in attorney's fees. This is a measured approach to avoid frivolous appeals. To receive attorney's fees, a claimant must be successful in their appeal, and the commissioner, again, want to emphasize the commissioner, has the determination to decide the amount of attorney's fees up to $2,000. So currently in these medical-only hearings, many attorneys refuse to represent claimants even if they have a good case because they can't get paid for their time or their expenses. So some attorneys take these cases pro bono, but what about the claimants who can't afford legal representation? They might be able to represent themselves at a hearing against a skilled insurance lawyer, company lawyer, but that's not usually what happens because they seek representation. So instead, claimants will either forgo necessary treatment or they use their private health insurance, medical assistance, or Medicare for injuries that should be paid by workers' compensation insurance. The last session when this bill was introduced and passed, but especially the last session, I had and my panel had hoped that there would be a solution that could be reached that would not require me bringing forth legislation. That solution has not come to fruition yet, and for these reasons, I would ask this esteemed body for a favorable report of House Bill 1012.
Good afternoon, Mr. Chairman. Again, members of the committee. Again, my name is Jim Lanier on behalf of the Maryland Association for Justice. The MAJ is, of course, support of House Bill 1012. We ask for a favorable finding. So since we have as Delegate Valderrama indicated, this bill's been here before, but to kind of paint the picture of what happens. Essentially what happens is that you have these longer term claims of which, for whatever reason, either the attorney has retired, the attorney has passed on, or is no longer representing the individual, that person can no longer find an attorney to represent them because their claims, as we talked about in the last bill, the need for medical care never ends. And these are people who, as an example, 2 weeks ago, I got a call from a gentleman whose attorney had passed away almost a decade ago. He was a permanently, totally disabled person. So he was already determined by the commission 20 years ago that he's going to need lifetime medical care. Well, his attorney has passed on. He can't find anyone to represent him. And I had to decline representation because there's no indemnity, there's no additional benefit beyond what the person is already getting. There's no way for us to get paid on that claim because unlike any other legal services that are provided, our fees are, we cannot contract directly with our clients. We only get a fee because the Workers' Comp Commission awards us, and that money comes from the money that's paid to the individual worker for the indemnity benefits, the benefit that the claimant can put in their pocket and do whatever they want to spend it on. So this solves the problem of unrepresented claimants who can no longer find an attorney in any other aspect, the ability for us to have the ability to earn a fee and quite frankly, also get our expenses back because we have to pay to get everyone's medical records, so we actually go in the hole to represent people. Because without this change to the statute, we cannot contract directly, and the commission doesn't have the ability, besides exemplary circumstances, to order a fee to us for the representation that these people are seeking. So it's a way to solve unrepresented for longer term claims, and we ask for a favorable finding. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Byron Warnken. I'm here on behalf of the Maryland Association for Justice. I've only been representing injured workers for a little more than 10 years, and I got into workers' comp for two reasons. First, we represent the Maryland State Troopers, Maryland Troopers Association, and our troopers are getting hurt a lot. And number two, my favorite book is The Jungle by Upton Sinclair, and I've been obsessed with how workers are protected or not in our capitalist system for a long time. And I got into workers' comp really excited, and without knowing the economics of it, having no idea of the economics of it. And I came to learn that, oh, attorneys get compensated on permanent disability only, which it never made sense to me, still doesn't. And I said, why is that? Well, that's just the way it is, was the response. That's just the way it is. That's just the way it's always been. And so what does this mean? It means there are a great deal of arbitrary and capricious denials of care by workers' compensation insurance companies. That's just the way it is. It has also led to a lot of unrepresented injured workers, which is an access to justice issue. You hear three common retorts, but the lawyer gets a fee at permanency is one of them, sometimes. And how are we incentivized to take a case where there will be no permanency? Number two, this should be handled by regulation. We're okay with that. And the Workers' Compensation Commission did set forth some substantive regulation reform, but it doesn't fully resolve this issue. The Maryland Association for Justice submitted comment. If those comments are accepted, it probably will. And number three, there aren't many of these claims, is another retort. My office, I'm just one law firm, and we get 2 calls a week. So there are a lot.
Thank you. Matt Pavel, thanks for this opportunity to testify live, Chairman. I shudder there when I just heard Mr. Warnken say 10 years. I've got 41 years under my belt of doing this, my goodness. And I have represented folks in the past knowing that there would be no fee on it. More often than not, they were my clients, and I just can't say no. But the compensation pool had dried up, and that's not unusual. Sometimes it's because a lawyer has retired or died or moved, and these poor injured worker still has a lifetime of medical treatment for which they can't fight. Honestly, it's David and Goliath in a court of law with an unrepresented injured worker going against these esteemed panel of defense attorneys you heard from moments before and who will be coming back out here to oppose this. They know how to quash a claim really quickly in a court of law. And even a commissioner who is sympathetic and wants to help, she is confined by rules of procedure and rules of evidence and ultimately has to deny it if the law so says. Now, one other point I want to make, and then I'll wrap, and that is that notice it's the discretion of the commissioner. The discretion of the commissioner. That's very important. 2 levels here. First of all, you have to win the case if you go in there. If you lose, no fee. And then if you do win, I mean, the commissioner could give a very nominal fee if he or she chose to. So that contains this, so there can't be any kind of out-of-control feature to this. Thank you very much for this opportunity to testify.
Thank you, Mr. Chair. This might be for the sponsor. So to be clear, if you bring this cause to, the attorney takes this, okay, and he brings it forward and it fails, the attorney gets nothing for that, is that correct?
Correct.
Okay. That takes me to my next one. One of the problems I've experienced with this whole workman's comp thing is that getting an attorney is very difficult. And even under this guise, if you have an attorney already of record that you've been working with and they don't feel your need is essential or real, they might sit back and say, I don't want to waste my time on something I may or may not win. Changing attorneys seems to be very difficult. Does this bill do anything to help the claimant with finding other attorneys?
Well, it does, particularly if they were declined because the compensation pool dried up. Now, an attorney can take on a perfect stranger, meaning a client who's a perfect stranger, not from their caseload, and say, sure, I'll go in, I'll take my chances, I'll look it over and see if it's a winnable case, hopefully, and it's supported by medical testimony, medical reports. Then it's an incentive. Yes, it will open the doors for the possibility.
2 more points, but back on this one a little bit. So I'm an injured person, and I really feel I have a claim. I feel hopeless at this point because you don't believe what I'm saying is going to work. Is there any appeal or somewhere where you can go to another source other than your attorney of record?
This may solve this problem. If we were to get that phone call, we would now be able to say yes without it being per se pro bono.
Okay, last part. I'm sorry, Mr. Chairman. Is this at the sole discretion of who to decide whether the attorney gets paid?
The commissioner.
The commission, or who does that? Can you name the body that does it? Is it a group?
The Maryland Workers' Compensation Commission.
Okay,
There's
how many
10
people?
commissioners.
Okay, that's
that
what
person, he or she would make the decision.
All right, thank you. Thank you, Mr. Chair. Thank you.
Thank you.
Yes.
Thank you again, Mr. Vice Chair, members of the committee. For the record, my name is Carmine D'Alessandro with Chesapeake and IWIF, here to respectfully oppose House Bill 1012. As Delegate Valderrama indicated, that this may be the third or fourth year that we've come back on this, but I think she sold herself a little short with saying there was no progress because there's been significant additions to the claimant's fee structure over the last 3 years due to Delegate Valderrama's persistence. 2 years ago, the Commission increased the fees for claimants' attorneys on settled cases. They then added a provision where claimants' attorneys could get fees on medical treatment cases. And just now, they have promulgated regulations, and the hearing is March 9th, increasing the entire fee structure for claimants' attorneys, raising the cap from $25,000 to potentially $85,000 a claim, and raising the other cap from 20 times the average weekly wage to 60 times the average weekly wage. So through the persistence of this bill, while it's never passed, the Commission has taken steps every year to enhance the legal fee structure for claimants attorneys. They're receiving more now than they ever have, and we would respectfully request that the regulatory process be able to carry through. Like I said, the hearing is March 9th. Those regulations should be promulgated, and then to see if there's still an issue after that. But we are basically at the finish line of these regulations. Over 3 years, there's been significant enhancement to the fee structure, so we think the bill now is obsolete given what's going on at the Commission level. And for those reasons, we would respectfully oppose. Thank you.
Lindsay Beidel-Menninger, Vice President of Legal Services at Chesapeake and IWIF. Just to give you an idea of the COMAR regulations that were updated in 2021, they allow for attorney's fees in exceptional circumstances for cases involving issues such as medical care and treatment, vocational rehabilitation, or which the claimant does not receive any monetary award. That has been passed by the Commission, and we have seen orders for that in cases of claimants that no longer have money to give their attorney, but they still have issues pending, particularly in long-standing detoxification cases for pain management purposes. And a me too.
Okay, seeing no questions, this concludes the bill hearing for House Bill 1012. Next, we'll go to House Bill 694, Delegate Boafo. You can start when ready.
All right. All right. Thank you, Mr. Vice Chair, colleagues on the House Economic Matters Committee. For the record, Delegate Adrian Boafo here to present House Bill 694. This bill makes a small but important change in allowing the Workers' Compensation Commission to authorize licensed certified social workers, clinical, to register as rehabilitation practitioners. HB 694 will allow LCSWCs to register with the Workers' Compensation Commission as a rehabilitation practitioner for the purposes of providing rehabilitation services under workers' compensation law. In addition, this bill will allow LCSWCs to perform an evaluation of the mental or behavioral portion of a permanent impairment claim as well. With major workforce shortages, especially in rural areas, this bill will expand the pool of certified professionals eligible to assist workers with rehabilitation and evaluation. With that, I urge a favorable report on HB 694.
Keep going. Turn your mics off.
I'm sorry. I didn't hear it. Okay. I'll just go. Good. No, I didn't hear what you said, Vice Chair. I'm sorry. Good afternoon, Mr. Vice Chair. Members of the committee, again, once again, my name is Jim Lanier on behalf of the Maryland Association for Justice, and we're here in support of Delegate Boafo's bill. So essentially, Delegate hit on the two aspects of this bill that would help injured workers. First off, that to give a little context, there are basically four major benefits of the workers' comp system. There's an out-of-work benefit, there's medical care that we've heard much about. The third and fourth benefit is where this would come into bat, which is the third benefit is a return to work benefit if the person is so injured that they can't go back to their pre-injury job. And then finally, at the very end of the case, once they're better and back to work, it's permanency. What, if any, permanent injury do they have? So start with the permanency. The issue that we have right now is when you go forward on permanency, you need to get an impairment report. Someone has to give you an idea of how much impairment there is to either the physical or the mental health as a result of the work injury. Currently, there are limited, maybe 3 physicians in the state of Maryland who do impairment reports for injured workers. That's it. One's in Towson, one's in Pikesville, and one's in Laurel. That's essentially all there are. So what this bill would do is, by having someone who's not necessarily, who's a licensed social worker being able to do an impairment report, is that, thank you, is that for them to be able to do the ratings, that allows people in the western counties on the Eastern Shore and Southern Maryland, they don't have to come all the way to the Baltimore metropolitan region or to Laurel to get the impairment ratings that you need to move forward on a mental health permanency claim. For the vocational rehabilitation portion, again, it's expanding the amount of individuals who are available to assist injured workers to returning back to work. Currently, we use vocational counselors for that purpose. But sometimes when you have a mental health aspect, because of the nature of that injury, a social worker might be more helpful than for lack of a better word, a regular vocational service provider. But all these people have to be licensed by their boards and then also certified by the Maryland Workers' Compensation Commission. We ask for a favorable finding. Thank you.
Arthur, you want to go?
Good afternoon. My name is Arthur Flax. I'm a licensed certified social worker clinical. I'm also registered with the Maryland Workers' Compensation Commission voluntarily. And I would like to publicly thank the staff of the commission for their work over the years that I've worked with them. Today, I'm sort of semi-retired, but I'm still much involved, and I still keep my certification active and my continuing education with the commission active. Just for clarification for a second here. Under the Workers' Compensation Commission rehabilitation section, a provider is the company that hires the person, whether you're self-employed or whether you're working for an agency. Practitioner refers to the person who is providing services under the Workers' Compensation Commission Department of Rehabilitation rules and regulations. Now, in my particular case, in the case of any licensed certified social worker clinical, and I want to make clear, because the other gentleman used the word social worker, we're not talking about all social workers. There's different levels of licensure. And only the licensed certified social worker clinical under Title 19 of the Health Occupations Law has the authority to independently evaluate, diagnose, and treat mental and emotional disorders, psychosocial conditions, very important, conditions and impairments. So we have also, going back to 2004, an Attorney General's advice of counsel from Kathleen Rowe, which states...
Sir, I'm going to need you to start to wrap up.
I will. In conclusion, it is my view that a licensed certified social worker clinical may be permitted to testify with respect to ultimate issues such as sanity and competence to stand trial. Ultimate issues. Permanent disability is an ultimate issue.
Sir, we give every witness 2 minutes. Thank you so much.
Well,
that's okay. If
other
there's
people
questions,
spoke
we
for
can.
much longer.
I'm not sure that they did, sir. But nope, sir. I'm gonna stop you there. If we have questions, we can follow up. Okay.
All right.
All right.
I'm
Go
willing
ahead.
to take any questions.
Thank you.
Thank you, Vice Chair. Matt Pavela with the Maryland Association of Justice. This is a great bill. I wish I had thought of it. It makes so much sense. As Mr. Lanier points out, I was going to say you can count on one hand in the greater Baltimore metropolitan area, doctors, providers that can give you an opinion for a permanency hearing that involves psychological injury. it's very difficult. And then you get to the remote parts of our county, it's even worse. This bill makes sense. It makes great sense. A licensed, certified social worker clinical, as was just made clear, it's a very, very tight definition, and they're very trained, and they are very much in the trenches. They know psychological injury if ever there is from their day-to-day work. I think this just makes so much sense, and I certainly hope and this panel will vote favorably for this very good bill.
Good afternoon again. Byron Warnkin on behalf of the Maryland Association for Justice. We urge a favorable report on this bill. The workers' comp process for many is long and difficult, and at the same time, the injured worker is dealing with their first time in their life where they're unable to support themselves. And there are substantial mental health issues that come along with this. And we have, as has been stated multiple times, a woefully insufficient amount of practitioners to provide voc rehab services, to provide ratings, and to provide treatment. And any bill that increases the amount of practitioners in the area should be looked upon favorably. An important point is these folks are capable of doing this work, and they're just not permitted to right now. So again, we urge a favorable out of committee. Thanks.
All right, thank you all. Seeing no questions, that concludes this bill hearing. Congrats, Delegate, on your first bill. Well, we still got to vote on it. Next, we have House Bill 902, Delegates Pruski and Rogers. Andrew, you want me to send Mike up there for moral support? You good? And you can bring up your panel if you have. I know Jeff was here. There he is.
Thank you, Mr. Vice Chairman. Committee, Delegate Andrew Pruski here, presenting HB 902. This legislation is pretty straightforward, and here's the question. Should a hernia as a result of repetitive trauma be covered in labor and employment statutes? And my answer is yes. Medical science has come a long way since our initial statutes on hernias were written into Maryland law, and certainly you'll hear that today, but as you know, common hernias are often what happen in a workplace and workers' compensation, and they happen by accident. The question is, though, and this is an example particularly for firefighters, it's not a one-time incident. This can happen by repetitive lifting, twisting, and sharp movement. And the question it comes down to, why is this not covered? And essentially, that's why we're bringing this forward today. We want to make sure we update our statute to be in line with current medical science and diagnosis. And I'd like to include that there is an amendment. I don't think the committee has it yet, but it's to clarify some of the questions that were brought up by the opposition, to clarify the language in regards to hernias, and I'm asking for a favorable report for HB 902. Thank you.
Good afternoon, Mr. Vice Chair. Jeff Buttle on behalf of the Professional Firefighters of Maryland. We represent over 10,000 professional firefighters, paramedics, and emergency services personnel across the state of Maryland. I also serve as the local president for Montgomery County. I know many of my Montgomery County delegates serve on this committee. I think the delegate did a great job introducing why it is that we need this bill, and I think it's important to remember, and Mr. Hall that's coming up next on our panel can describe some of the challenges that we've had at the Workers' Compensation Commission is currently for these types of hernias, you can't even file the claim. That's supported by case law from the courts. And what this would do, it would allow for these types of hernias that firefighters often develop to be able to file the claim, make their case before the Workers' Compensation Commission. It would also allow the employer to provide any defense on these claims before the commission. And I think it's also important to remember, Mr. Vice Chair, that the only way we have to address these issues is to come to the legislature and amend the workers' compensation statute. Employees don't have a right to sue their employers over these claims for work-related injuries. So we're left, when we find these issues coming up before the commission that are preventing our members and our employees from filing claims and having them heard. Our sole remedy is to come before the legislature and ask for the changes in the statute. So with that said, we support this important piece of legislation and ask for a favorable report. Thank you.
Thank you very much. Good afternoon. My name is John Hall. I actually was a prosecutor in Prince George's County for 6 years in narcotics, and I now represent injured workers in the state of Maryland. The reason we're here is because I filed a claim purposely because the statute in the state of Maryland does not recognize repetitive trauma hernias. That's the only injury in the state of Maryland that's repetitive that's not, we can't even file the claim. We filed the claim with the State Workers' Comp Commission. The order came back, and the commissioner was correct in his interpretation of the law. The order stated, the employee did not sustain an occupational disease, a hernia. Pursuant to Maryland law, a hernia can only be compensable as an accidental injury. Hernias as an occupational disease are not recognized under the current statute in Maryland. So what that says to everyone here is, if you go to the gym or whatever you do, lifting patients every day as a firefighter, it's almost impossible to point to one event that caused your hernia. Over time, you're lifting patients as a firefighter. Over time, you're a waterman, you're lifting crab baskets. Over time, you're a farmer lifting things. It's impossible to say, yeah, you know what? That event right there is where I blew out my abdominal wall. That's what the current law says. You cannot file the claim as repetitive use. We aren't even allowed to file it because the law states we can't. And when I hear those opposed last time in testimony saying, well, we accept these. Well, they're not filed because lawyers don't take them because the law states that you have to have a singular event to cause the hernia. Repetitive use, the science shows it now, may not have shown it back in the day, but just like carpal tunnel syndrome, we still have to go before the commission. We still have to prove our case. We're not asking for a presumption. We're only asking to be able to be heard, to have our witness testify or claimant testify as to how they got it, and then they can rebut it with their expert witnesses saying why they believe it wasn't at work. We ask for a favorable ruling.
Thank you. Seeing no questions, that concludes this panel. We have Matt Pavola and James Lanier next. And you can start when ready, sir.
Good afternoon, Mr. Vice Chair. Again, my name is Jim Lanier on behalf of the Maryland Association for Justice. Essentially, we're in support of this bill as well. I don't really have anything additional beyond what the panel has said, so we'll just say me too.
Perfect. And that goes forward for everybody else. If it's repetitive or you just want to follow up with somebody, just a simple me too is sufficient. All right. Thank you. Seeing no questions, that concludes this panel and the favorable witnesses. We will now go to unfavorable. We have Lindsay Menninger and Carmen D'Alessandro. You can start when ready.
Thank you, Mr. Vice Chair. Again, members of the committee, my name is Carmine D'Alessandro with Chesapeake Employers Insurance Company and the Injured Workers Insurance Fund, here to respectfully oppose House Bill 902. Mr. Hall is correct. The latest pronouncement from our court in 2020 was that certain types of hernias were not compensable under our law. Hernias are treated differently from any other condition that I know of. The only hernia that is acceptable is a hernia that you can pinpoint, a tear, and the reason is notice. As Mr. Hall indicated, these repetitive hernias that are called athletic hernias can happen anywhere, anytime, and you won't know about it for months or even years later, and it's impossible to pinpoint what happened. So the courts have made a determination. While normally the act is construed in the light most favorable to the injured worker, this is one instance where it's actually construed most favorable to the employer, saying it's impossible for an employer to figure out where that hernia came from. So that's the genesis of the case law that's been around for 70 years. Having said that, I understand there is an amendment circulating, and there may be another one circulating on top of that one, that we may be able to provide an avenue where injured workers can file for a hernia for an occupational disease. It's just a question of where we would put that in the annotated code as opposed to putting it in the section it's in now. So there are active discussions going on over the amendment, but barring a compromise on those amendments, as of now we oppose House Bill 902 in its present form. Thank you.
Me too.
Perfect. Any questions? Delegate Aaron's.
How do you address that currently then? If let's say this was a real event that was caused at work, how is that person compensated today?
So if it's you have 45 days to tell your employer that you strained yourself or have a hernia. Once the commission accepts it, it's then treated as any other condition, so like a back or a wrist injury, so you get the same types of benefits. The issue is you have to give notice to your employer under the current law within 45 days of actually feeling that strain.
So I'm a fireman, and we go to a fire, I pull a hose off a truck, I feel something. I don't know what it is yet. It doesn't just not hurt. I have an effect. I've never had a hernia, that's why I'm asking the questions. And I'm not a doctor yet. I guess I'm just trying to figure this out. So I pull that off the truck, I'm hurt. I go to the gym the next week and I'm doing some things and it hurts again. I come back into work the following week and I go out on another truck and boy, I do something else that hurts. So that's all within 2 or 3 weeks. That's not a lot of time. I then go to the doctor then tells me I have a hernia because, or maybe am I not understanding how bad or what the degree of a hernia can be. That's what I'm trying to figure out how we work with somebody.
So I've never had a hernia either, thank goodness. But in the scenario that you gave under the law, within those 2 or 3 weeks, now you've reported it to someone, and that notice, so you're in that 45 days. So then it'll be looked at. If you were to actually give notice on the 67th day under the current law, your hernia claim would be barred. So with these athletic hernias, you're never going to know within those 45 days because it takes months or even years for it to develop. That's why it's called an athletic hernia. It's not called a work hernia. So,
but it will develop. It will come out. I might have hurt myself in high school, but I started it in high school. But as I'm working, I'm going to get an event where I know something happened when I did something. Something changed. I go to the doctor because it's probably hurting enough to go to a doctor, and we're all aware of it. So something did change. I can't point it to an event. I was pulling a hose off.
So that's a very good point. So under the current laws, let's say you had something in high school that's sort of simmering there, but you don't feel anything. But then an event occurs at work that either strangulates that hernia or brings that hernia to the fore. You have 45 days from that event so there is an allowance in the law for something that's sitting dormant, that something work caused to spring forth, but then your 45 days would start running from that work event.
Okay, last question. How many have you encountered that went past the 45 days and then they came back to claim?
Well, 3 years ago, we encountered one at 35 days, and we made it 45 days from 30 days, but not very often. Most people know immediately that they have an issue. So even in your situation, your story with the 3, by the first one you knew and you went to the doctor because you were in a lot of pain. You didn't go to the gym.
My question was, how many have come in after the 45 days that you didn't honor?
We don't have that
None.
data. We have 130 filed claims in the last 5 years.
The only case, Delegate Aaron's, that came in after the original 30-day limit, the law was changed the following session so that's the only case I know of recently.
Okay, thank you very much. Thank you, Mr. Chair. That's good, thanks.
Delegate Harrison.
So an individual who, sometimes we work through our pain and we keep on. And then, now it's 50 days. It's like, okay, enough is enough. So then they're not injured enough for you to consider a claim for them just because they decided to work through it. I mean, I've never had a hernia either, so I have no idea how bad it is. But I've worked through pain.
Absolutely.
Certainly, and I'm sure most people have. And then finally, it just gets to be, okay, this is enough. Let me go see what's going on. They find out it's a hernia. They can probably pinpoint when it started, but now it's 47 days, and so they don't have a right to file a claim or to be compensated for it.
With hernias, all there other injuries where you work with your pain, you actually have 2 years to file. So this is the one incidence in the issue in the law where it's treated differently from every other type of injury. You are correct.
Okay, thank you.
All right, seeing no further questions, that concludes this panel and the bill hearing. Next, we'll go to House Bill 919. It's Delegate Rogers. And Delegate Rogers, you wanted your intern to brief? Is he or she here? Oh, my bad, I'm not even looking. Sorry. Got you. Welcome. Go ahead, take your time. No rush.
Thank you.
Whenever you're ready.
Good afternoon, Vice Chair Crosby and members of the Economic Matters Committee. My name is Marjona Asherbova, and I'll be testifying on behalf of Delegate Mike Rogers for House Bill 919. I respectfully request a favorable report on House Bill 919. This bill will repeal the requirement that certain firefighters and other specified related fields experience partial or total disability or death for hypertension to be presumed an occupational disease that was suffered in the line of duty and is compensable under workers' compensation law. Currently, hypertension is recognized in statute as an occupational disease presumption under 9503 of the Labor and Employment Article. This would amend that section to remove the requirement for disablement. Currently, under prevailing case law, disablement is generally considered 3 or more lost days from work. The Workers' Compensation Commission has been denying hypertension claims under 2 scenarios. 1, the employee is placed on medication after visiting a physician and is returned to work, or 2, the employee is placed on medication and misses more than 3 days of work as directed by a physician and claims are still being denied. Under either of the above scenarios, the Workers' Compensation Commission is essentially nullifying the intent of the General Assembly that hypertension is a presumptive occupational condition under 9503. For these reasons, I respectfully request a favorable report on House Bill 919. I will be followed by Jeff Buttle.
Good afternoon again, Mr. Vice Chair. Jeff Buttle, on behalf of the Professional Firefighters of Maryland, representing all of the firefighters, paramedics, and emergency medical services personnel across the state of Maryland. Let me just start with a note, Mr. Chairman. What a great job from Delegate Rogers' intern presenting that bill. She did that like a seasoned Annapolis delegate. Very good job. I'm going to cut down on some of the Me Too testimony, Mr. Vice Chair, at your suggestion. Many of my points that I was going to cover got covered in the introduction. I do want to, however, make it clear on the record that we are trying to fix, part of this bill is trying to fix a decision from the Maryland Court of Appeals in Spivak versus Montgomery County. I did attach that decision to my written testimony that I submitted to the committee. If you read the dissenting opinion by Judge Watts, that perfectly describes our viewpoint of not only the case law history, but also the legislative history, how we view it. So I'll incorporate that by reference and encourage a favorable report. Thank you, Mr. Vice Chair.
Afternoon, Mr. Vice Chair. My name is Kenneth Berman, and almost practicing as long as Mr. Pavela, about 40 years representing firefighters, but I think he has me beat. I'm going to try to be very brief. The purpose of 9503 and hypertension was to protect firefighters and first responders who develop hypertension. We spoke about that in various other bills today, because their incidence of hypertension is so much higher than the general population, as well as heart disease. The problem that we run into is that in the statute, you are required to show a disablement, not just a hypertension. The real problem is there's no definition of disablement. So we have 12 commissioners all trying to do a great job who define it differently. And our courts have not told us what a disablement means. It comes to tell us what it doesn't mean, but it hasn't really ever told us what it does mean. So I had a firefighter about 3 weeks ago who went for his annual physical exam, had been a firefighter for 25 years, suffering from PVCs, heart palpitations. They took him off of work. They put him on a Holter monitor. They put him back on light duty. He eventually went to full duty on medication for the rest of his life. And the county that I am in, Montgomery County, fought the claim on the idea that he did not have a disablement. Even though he's on lifelong medication, their doctor said he has an anatomical permanent impairment and he missed time from work. So what this bill seeks to do, and we've spoken to both Chesapeake and others about even tightening it up, and I think we're close to a resolution, is to put some parameters on what is a disablement, so we won't be lost and they won't lose those cases even when they are suffering from something that they have to take medication. Because if they don't take the medication, they won't meet, they don't take the medication, they won't meet the physical requirements of their job, which each county and each municipality has. Your blood pressure has to be under a certain level.
Sir, I'm going to need you to
in
start to
order-
wrap up.
That's it, I'm done.
Go ahead, Mr. Hall.
Thank you. Again, John Hall. I proudly serve firefighters and police officers in the state of Maryland. I'm here as well to just a little common sense here. We have to show disablement when you have hypertension. Well, if you don't take your medication, you're going to have a stroke or you're going to die. So having hypertension and having to take medication and to perform your job as a police officer or firefighter, that's disabling enough. And we're asking that this disablement, when you're medicated, when you're diagnosed, that you are compensable, because hypertension in and of itself is disabling. I can tell you personally, last time I was here, I heard my opponents talking about how, oh, well, if you don't miss work, your case will just be denied because it's not ripe. And then your client can come back a year later, 6 months later, go to his doctor, take off a day of work to get his medication, and then you can go back and get it made compensable. That's not how it works. That doesn't happen. Every single one of my cases are fought. Mr. Berman and I do the lion's share of hypertension cases and heart cases in the state of Maryland. I think out of, if I could say 1,000, maybe 10 haven't been fought by the insurance companies, and 5 of those are because someone made a mistake and didn't check off the right box. So don't be fooled that they fight every one of these cases, and the issue is, the presumption is your hypertension is related, you have this. But now you can't get there because you don't miss 3 to 5 days of work because of your blood pressure, but you're taking your medication. Why would you miss work at that point? I would ask you to find favorably to the report.
Delegate Sample Hughes.
Thank you, Mr. Chair, and thank you, panel, for being here, and thank you, Delegate Rogers, for the bill. I wanted to just expound upon a little bit more on the disablement part. With there being no definition, would you agree that the date of the diagnosis could be settled as the disablement, or the date someone begins taking the medication?
It's a great question, and the conversations we've been having in the hallways has been as perhaps that it's a date you were put on medication. The diagnosis, which is when they normally put you on medication. But we're even willing to go beyond that. In other words, if the doctor diagnoses you and says, I want you to basically take 4 weeks or 8 weeks of weight loss, eat properly, do exercise, and then he releases you and they don't put you on medication, we're fine with not even filing a claim at that point. Our thing is, though, clearly once, and maybe this is the demarcation, but clearly, once the diagnosis is made and you are put on medication and you have to stay on that medication in order to meet the requirements of your job, in order to do your job, then you're faced with what we say is a Hobson's choice. You either take your medication and do your job and you don't have a comp case, or you don't take your medication. Doesn't jeopardize your health. Doesn't seem to be the purpose of the statute. But yes, that's exactly what we're trying to do.
Okay, thank you. And then my second part of that, with having this definition of disablement and knowing that our firefighters and police officers get annual assessments, would that harm them at any given time for anything else that they might try to or be in need of? No.
Not that I know of. Is they as long as you're, is my understanding, and Jeff knows the labor part about it much better than I do. But if you take your medication, you're able to do the essential functions of your job as a firefighter. And I think 99% of our people do that and then are able to do that. There's no negative consequence on their job. They want to work. They want to continue to work. They also want to take their medication and be covered for it. So,
Yeah.
yeah.
Thank you.
Delegate Arons.
So you mentioned that you go your annual checkups. That's when they'll determine if you have hypertension, because last year you probably, if you did have it, they've noted this, so it starts, they look at it from that date, is that correct?
Medicated, right?
But what we were going to say, is, yes, that's when, what happened. You want to take? No, I'm only kidding. What normally happens is they go through their annual county physical, their blood pressure is elevated. What will happen is the county physician will say, I'm referring you to a cardiologist. You cannot come back to work, you cannot fight fires until you see a cardiologist or your family doctor, but normally a cardiologist, 4 weeks later. And at that time, the doctor, not the county doctor, but the private doctor, makes the diagnosis, puts them on medication. That would be the time that we think that it would be the disablement.
Okay, so moving forward with that then, if I have a hypertension, let's say I have hypertension and I can't do my job as a firefighter, I'm going to be part of this bill. Okay.
Yeah.
What if I come back to the fire department and I get desk duty or some other job at the fire department? Do I collect this compensation while I'm on duty in another position? Is this related to me being a firefighter, not me being, I don't know what that would be, maybe a paramedic who, well, that's even kind of tough because they still have to lift.
And if the question, as I understand it, is if you were on medication, but they reassign you to
Correct.
a different job. Yes, because then you will have, it has affected your job, both by taking the medication and because of your hypertension, they put you on.
Even if it was the same pay grade?
Yes, Maryland is not a wage loss
Okay.
per se,
Well, I'm
yes.
just asking questions.
No, it's a great
I'm not trying to stump you here. These are important to me because I know a lot of these people.
Some states have that you were required, the District of Columbia, for instance, it's pure wage loss. You have to show a loss of wages. Maryland, since 1914, has never had to do that.
Last question then. If I have a history in my family of hypertension, does that play any part in this?
It does, it allows what Mr. D'Alessandro said before, and there aren't that many things we actually disagree on. It's not an irrebuttable presumption. The counties or the cities many, many times come in and say, even with the presumption, and even though you're taking medication, your heart disease is not related because you're obese, your 4 siblings had hypertension.
Well, you don't have to get personal.
Smoke. I told you should have taken this. He wouldn't have done that to you. But yeah, they fight it on. It goes to whether or not you've met, even with the presumption, whether or not you can prove your case.
Okay, thank you very much, and I'll see you later.
That was good. All right, seeing no further questions, that completes this panel. You did great. Is it Marona? Marjona. Great job. All right, James Lanier.
So good afternoon again, Mr. Vice Chair and members of the committee. Again, my name is Jim Lanier, on behalf of the Maryland Association for Justice. And if I can, I just wanted, if I may dial down a little bit on Delegate Arntz and Delegate Sample Hughes' questions. I believe, Delegate, you were focusing on the work. There's the 4 benefits of workers' comp. The reason this bill is important is because it would help the medical care part. The out-of-work part, if you're working, you don't get the out-of-work benefit. You're just earning your wages. So if you're working a different duty, a lighter or modified job, you don't need that benefit part of workers' comp. But what this bill would do was give the medical care that is the most important part of any workers' comp claim. It is, I always jokingly say that there's a top 10 of comp benefits, it's all medical care, because that's the most important benefit to the injured worker. Until the claim is compensable, until it's a good claim, you're not entitled to any benefits. So until you have a date of disablement, nobody but you and your health insurance pays for any of the medical care. That medication, those doctor visits, the cardiologist, the primary care physician, until you have a compensable claim, you're on your own through your health insurance or some other means, not the workers' comp provider, to pay for all that medical care. So this bill would, once they're on medication, for example, then it becomes that person can maintain their general health knowing that their medical coverage is going to be covered because now they have a quote-unquote compensable claim and they're entitled to that medical benefit. Beyond that, it's a me too for me. Thank you.
Delegate Adams.
Oh, sorry.
Yeah, thank you. So is MACO testifying on this bill?
They are not.
So in their testimony, they say courts have consistently ruled against employers on issues of presumptions, rendering these presumptions effectively irrebuttable. And I guess my question is, because I think this is the last bill we have that relates to presumptions, is this idea that is different than what I heard from the prior panel. and that the courts quite often will take into account certain things, notwithstanding the rebuttable presumption. But my experience with law is that once you get to a point where there's a rebuttable presumption, proving that negative is not workable in the setting. I don't know if you would agree or disagree in that assessment or not, but I felt like I wanted to ask the question.
Well, Delegate Hershey, I mean, the hypertension is already a presumptive disease. So all we're doing is modifying what is already the law to make diseases, because like I believe the undercurrent here is if you're on your medication, you're not going to miss time from work and you're not going to have that data disablement because you're controlling that condition through your meds. So you'll never have that data disablement. What this fixes isn't that these people have hypertension and it's work related. It basically, when you lose these claims, and the other two gentlemen may or may not agree with me on this, is because you're there too soon. You don't have that data disablement, so the commission essentially says, come back later when you've really had that impact on your job, and that's what Mr. Hall was indicating. Then they come back a year later, didn't take their meds, and God forbid something bad happens, and then they actually start missing time from work. This fixes that problem. The presumption is already there. It just fixes the data disablement piece of that so that they can get the medical care and other benefits they may or may not need.
Okay, seeing no further questions, thank you. We'll go to the unfavorables. Lindsay Menninger, Carmen D'Alessandro, and Ashley Smith.
Good afternoon once again, Mr. Vice Chair, members of the committee. For the record, Carmine D'Alessandro with Chesapeake Employers and the Injured Workers Insurance Fund to respectfully oppose House Bill 919. I understand there are amendments circulating that may define what disablement is, and we certainly will look at those amendments to see if there's an area to compromise. As the bill stands now, we oppose the removing completely of the term disablement from the statute, and it's actually for the trickle-down effect that we'll have in other areas of the Workers' Compensation Act. Every occupational disease in workers' compensation, there are two elements. The disease arose out of your job, and you were disabled. So whether it's asbestosis, whether it's carpal tunnel, whether it's degenerative knee disease, or whether it's hypertension, disablement is an element of every single occupational disease. Moreover, to gauge statute of limitations, to determine when a covered employee's time starts to run, if they're 2 years, it's 2 years from the date of disablement. So by removing that word, you've now thrown limitations into sort of an ambiguity because we don't know when to start the clock running. And most importantly for these types of diseases, many times two employers are trying to determine whose case it is. Is it Montgomery County Fire Department or the person retired to the Eastern Shore and now they're working for a volunteer company? Well, to determine which company it is, we use disablement. We figure when they are disabled, and then we look back in time for the employer they were working for. So again, without this word in there, it causes more evidentiary problems. So we certainly will look to an amendment that defines disablement. Right now, Maryland courts have defined disablement as a case-by-case analysis. So it's never the same. It's the facts of the case at hand, and that's what we've been operating under. But we certainly will look at any amendment. Thank you, Mr. Vice Chair.
Lindsay Beidel-Menninger on behalf of the Chesapeake Employers Insurance and the Injured Workers Insurance Fund. I'd just like a quick note that just because a claim is denied for lack of disablement, it's not disallowed permanently. It's disallowed for ripeness, meaning somebody can come back at a later date when they have disablement currently. So a firefighter does not currently have disablement. He needs an increase of medication and a couple of days off to readjust to those medications. He would then have disablement and a compensable hypertension claim under the current law. I just reiterate the importance of disablement in the rest of the workers' compensation statute because it runs not only the statute of limitations and who the responsible employer insurer is, but also the average weekly wage for purposes of computation of benefits.
My name is Ashley Smith. I'm here on behalf of the Maryland Defense Council. I would just like to build on what Mr. D'Alessandro and Ms. Menninger indicated by pointing out that this is a Workers' Compensation Act that we are talking about amending. The Workers' Compensation Act is here for disability. It is not a general health insurance provision. We are here to compensate injured workers who sustain a disability as a result of an occupational disease or accidental injury. By eliminating a disablement requirement, you are setting up workers' compensation carriers and employers as general health carriers, and that is not what we are here to do. We are here to provide compensation benefits, and we believe strongly that those compensation benefits should only be payable when an injured worker is actually disabled by his or her condition. And for that reason, we would request an unfavorable report.
Delegate Aaron's.
Thank you, Mr. Chair. However, this is for you, really. I represent the Eastern Shore, and we're really lucky. We have really good volunteers. Super. But you mentioned something I'm a little confused about. A lot of our volunteers do this for a living also. That's how they make their life. You mentioned something that said that if they come in there, let's say I work for Prince George's County and I work at Queen Anne's at night. How do I know where this goes? If I have hypertension, how do I know where that?
So if you were to file a claim and you've left Prince George's County and now you've gone to the shore and you have that prior employment and now you're volunteering somewhere on the shore and you file a claim, we're going to look through your medicals. Well, first of all, you're going to claim on your claim form through your attorney, I was disabled on this date when I went into the hospital, when I increased my medical. You're going to pick an event. And we're going to look at that event, and then we're going to look back in time for the case law and say, okay, here's the event, January 17th of 2019, where firefighter Aarons was hospitalized with a heart condition. Looking back in time, you hadn't started on the shore yet. It's all Prince George's County. It's going to go against them. If you were, say, you were working for the Eastern Shore volunteer, say in 18 and 19, and you had left Prince George's County, say in 16, looking back in time, it's going to land on the volunteer company because that's your last injurious exposure, meaning that's the last employment you had where you were exposed to the hazards of that disease. So that's, if you understand, that's how it works.
Okay, is there a difference between what my volunteer compensation is versus my paid?
It would depend on the wages, so there's a whole different computation of what a volunteer, so if you had another employment, so you're working for a volunteer company, not making any money, but you have some other employment, there are different things we would look at to come up with that wage, but it would not be based on your wage as a Prince George's County firefighter. So it depends what you would be doing.
The answer is yes. The answer is yes.
Yes.
Okay, thank you very much. Thank you, Mr. Chair.
All right, seeing no further questions, that concludes this panel and this bill hearing. Next, we'll go back to Delegate Pruski, House Bill 590. Delegate, you can bring up your panel.
Somebody will switch out because there's 5, right? Yeah. Yeah, they'll switch out. Somebody's going to have to get out. Yeah, switch out.
Actually, we're good. It's just us 4.
Thank you, Mr. Vice Chairman, and the committee. Again, this is testimony in regards to the offset and hearing loss bill, which is 902. And I'm going to start with some opening remarks. Give me 1 second, if you don't mind. Okay, today I'm presenting HB 590. The legislation deals with workers' comp benefits, offset and hearing loss. The purpose of this bill is to address both medical and legislative updates. And these are based upon workers' compensation claims, judicial review, and a fair and reasonable standard. There are really 3 things that the bill sets into, and it was already mentioned earlier, the SPVAC versus Montgomery County. That provided a fundamental shift in how we looked at workers' compensation claims, and really it changed precedent. And I know it was shared in some of the testimony and other pieces, but the way I would put it is that there was pre-SPVAC and post-SPVAC. Pre-SPVAC basically would allow no offset if somebody had 2 injuries regarding to an occupational disease. Post-SPVAC, there's been some changes, and this bill is meant to change that and get back to where we were. We do have an amendment that's been brought forward by some of the advocates to try and clarify the offset language, so we will be presenting that. Of course, you'll hear some others today. The second part is hearing loss. So the best way to describe this is I had an example as a career firefighter in Maryland. For those of you that don't know, medical testing has changed over time in regards to hearing loss. And when you look at the current statute, again, written some time ago. You basically have, when you're over 50, a half a decibel, you're penalized as a firefighter. As we know, medical science has changed over time. You could have hearing loss at any time. You could have it at 30 years of age. You could be on a work site or something occurs, and that exposure could happen much earlier, and certainly to have that. And I want to give an example because I think this really puts in the tone of why we have to change that part of the statute. Say you had two employees, both started with the fire department on the same date. They had the same exposure to noise, both filed a hearing loss claim at age 60. Both had the same hearing loss, but one retired at 50 and another at 60. The one who retired at 60 would be rewarded, if awarded, significantly less, even though they had 10 additional years of exposure to noise. Preserving somebody's ability, the impact of hearing, is a quality of life issue. I think it needs to be addressed. And of course, last but not least, we have tinnitus. For those of you who don't know what that is, it's ringing in the ear. In the compensation statute, it's really unclear. We want to clarify that. There are some folks who will also testify that today. You've heard over and over again of opposition to bills of workers' compensation, but let me make something clear, and especially something that I've kind of seen in the law. We want to make sure that things are fair and reasonable. And we want to remind everyone that your award or your claim is not always proven. There's a burden of proof, and that there's a due process standards, the benefits are guaranteed, and I want you to remember that as we put this in the statute, that you still have to prove your claim and case. I would ask for a favorable report on 590. As I mentioned earlier, there'll be an amendment coming forward to clarify that offset language to make sure that we have some clarity with that, and I'll turn it over to the rest of the panel. Thank you.
All right, thank you, Mr. Vice Chair. Jeff Buttle, again, on behalf of the Professional Firefighters of Maryland. We have a great panel here who's going to get into most of the details, so I won't go into testimony that is duplicative. I will just make a side note that there is some unfavorable testimony on this, but we are working with the representatives from the unfavorable side to try to come to a compromise on some amendments that would fix the issues that we've identified and meet the needs of both sides. So thank you, Mr. Vice Chair.
Good afternoon, Mr. Vice Chair. Matt Darby of the Darby Law Group. I've been representing firefighters for over 30 years, which kind of makes me the baby of the group so far, so I'll take that. I wanted to talk a little bit about the hearing loss, and the delegate did such a great job when talking about the age penalty, as we call it. And that's the exact same story and example that I use with clients. So I'll focus on the tinnitus aspect of the bill as it applies to hearing loss. There's been discussion about disablement with our prior bill on hypertension, and the exact same issue, and maybe even a little bit harder, applies with tinnitus. So right now, because of a case that was cited a year or so ago, we have to show, in order to have a compensable tinnitus claim, we have to show that the tinnitus has created disablement. Just recognizing the challenge that we talked about with hypertension, it's even more so with tinnitus because there's no medical treatment for it. And so we've had a really hard time. So people have this incredibly aggravating and sometimes very debilitating condition that yet goes uncompensable because of an inability to show disablement. So what this bill would do would be to add disablement to basically the hearing loss calculation. We're blessed to have here Rory Cernick. I have represented clients in probably hundreds and hundreds of hearing loss cases. And Rory is the president and CEO of the Hearing Assessment Center. And so many of our hearing loss clients have gotten hearing aids and evaluated through the Hearing Assessment Center and Rory. And so he's here to answer any technical aspects of hearing loss that you may have in terms of the calculation and explain from his perspective how tinnitus and hearing loss interplay. And how was that for timing?
Thank you for the kind introduction. Thank you for the kind introduction, Matt. My name is Dr. Rory Cernick. I'm an audiologist. I own the Hearing Assessment Center. My team and I have had the privilege of helping over 500 firefighters in these past few years, and I want to talk a little bit about what happens with excessive noise exposure. So even with hearing protection, often people develop hearing loss, and what happens is that there's damage in what's called the cochlea. The cochlea really is our sense organ of hearing. It's like the retina in the eye. And when there's damage to the cochlea, what happens is there's hearing loss and tinnitus. Tinnitus, tinnitus, however you say it, it's equally as challenging. So for some, they have a limbic system response where there's an emotion because of it. So with tinnitus, it can be very mild, but for some, it can be quite severe. I've had a few patients who have even become suicidal. But the point is that when there's excessive noise trauma, hearing loss and tinnitus go hand in hand. Now, once hearing loss is diagnosed, there is an urgency of care. So hearing loss is the most modifiable risk factor of dementia. So once there's hearing loss, every day that goes on without proper care and treatment, the likelihood of falling increases, isolation, anxiety, and cognitive decline. So I want to express the urgency with that. And of course, any questions, I'm happy to answer. Thank you.
Afternoon again. I'm briefly going to talk about the set-off part, or what was referred to as SPVAC. So on both sides, the opposition as well as us for 40 or 50 years dealt with the way the state of the law was, and that was 1 year before SPVAC, what is now our Supreme Court said, the General Assembly, talking about all of you, wished to provide only a single recovery for a single injury, close quote. And as I said, that's where everybody in the workers' comp world operated under. Then came Mr. Spivak, and this is what changed the law and what we hope to go back to the way it was. Firefighter Spivak was a firefighter for 34 years. In 2007, he suffered a serious back injury. It forced him to go out on service-connected disability retirement in 2010. In 2012, he developed hearing loss. He did not have hearing loss in 2007 when he was injured, or in 2010 when he went out on service-connected disability retirement. The court said that because he went out on service-connected disability retirement, he could not get any workers' compensation benefits for his hearing loss, even though it had nothing to do with the back injury or his service-connected disability retirement. So just to be clear, this bill does not seek to get anybody any benefits that they would not ordinarily get under a workers' compensation case. It does not seek to get anybody double benefits. It simply recognizes that if you get injured for your back and you go out on service-connected disability, you don't get workers' compensation for that. But if you have a different disease or injury, the purpose of the statute is to compensate. Almost as close as you. Got
Delegate Fisher.
Thank you. Thank you, Mr. Chairman. To the doctor, I know that you can measure, obviously, definitively blood pressure, which was another bill I know, but tinnitus or tinnitus, how do you measure that? Because I didn't hear how you measure it from your testimony.
So with tinnitus, tinnitus, there are three subcategories that can cause it. Emotions can cause it, so a traumatic event, death in the family, loss of occupation, spinal disease causes it.
This is ringing in the ear we're talking about?
Yes, ringing in the ear.
Okay.
Right, ringing, buzzing, hissing, whooshing sound. There's quite a few ways people describe it. So the second bucket would be spinal disease, would be dentition, jaw issues, abscess, etc. By far the most common, and obviously we talk about it in the office, but by far the most common is noise trauma. It is subjective, and so there are a few things that we can do in the office to identify it. One is we try to match the intensity. So they're in a sound booth, and we try to play different sounds with different intensities to try to match where their tinnitus is. Okay. The second and more objective is there is a standard handicap inventory for tinnitus. It's a 25 question questionnaire, and it will give us an emotional, social consequence of tinnitus. It's standard in our industry, but that's how we generally address it.
Thank you. So in other words, this would be pretty easy to fake, say you have tinnitus. I mean, because there's no way of testing it, so there's a presumption for something that you can fake. I'm asking you as a medical doctor. I'm not in any way criticizing. It just seems like a fair question.
Sure. Could it be faked? Perhaps. But if we know it's coming from noise trauma, which is very clear to see in the testing, the vast majority of the time tinnitus is there. But could it be faked in general?
Sure. Unlike blood pressure, which you can measure and it's definitive. Thank you.
So question is somebody who has tinnitus and my ears ring constantly. Let's put this in context of the VA, right? So when I get out of the Army, they go through a whole checklist of here are your injuries that you accumulated while in service, right? So for me, it was my shoulder, it was my knee, and it was the ringing in my ears. And then they identify that and match it on a chart, essentially, to what percentage. Now, there's varying degrees. For tinnitus in the military and the VA, I think it's just 10%. They just give it to you because you're not going to get more than that. You're not going to get less. It doesn't matter how much it rings, although it's quite frequently. So under this bill, essentially what we're saying is, if we were to use a military example, if I were discharged from the Army in 2010 with a shoulder injury, and then my tinnitus kicked in 2012, and I could tie that, is that a key? I have to tie it back to my service disability or my time in the service, then I can be compensated, and my compensation can be adjusted then from the VA for the hearing loss. Is that all this bill does, or am I off?
May I address that,
Yep.
Mr. Vice Chair? So what the bill would do is to tie tinnitus into the hearing loss section. So, essentially what Dr. Cernick was saying is, when you measure hearing loss, that is more objective, although there's no presumption for tinnitus, but it is more objective because it's measured in the sound booth, et cetera. Here, because tinnitus, and I didn't hear Dr. Cernick say it, but I think you would agree, is also something that impacts a person's ability to hear. So, for example, I've heard, many clients say that part of the reason I can't hear in a room with background noise is because I also have the tinnitus and it's distracting. So what we're doing is just moving this in and say, let's put it all within the hearing loss section so that it's not two separate analysis. So right now what happens is you get a binaural hearing loss award, and if you are able to show disablement with all the problems that we talked about that are also relevant to the hypertension issue, then it's done under an entirely different analysis for permanent impairment. So let's just put it all together, treat it as one, which is what the bill attempts to do.
Okay. All right. Seeing no further questions, that concludes this panel. Next, we will go to No, we're not done. Sorry, delegate. The order, my list is a little bit off. I think we got Matthew Darby, right?
Yep.
So we will do.
This won't be very long.
I think that. They're just written. Okay, we'll go to favorable with amendments. I have Milton Nagel and Bill Kress.
Oh. Vice Chair, I believe I signed up for this one as well, Lanier.
Yep, go ahead, James. Sorry.
All right, as I just said to the delegate queen, I'll try to be quick on this one. So again, James Lanier on behalf of the Maryland Association for Justice. I kind of just wanted to go back and kind of answer Delegate Fisher's question, if I may. So in any workers' comp claim, you obviously have objective and subjective findings. So,
Hey, sir. Sorry, James. Can you slide that mic over?
oh, I'm sorry. So to answer your question about it all being objective, you're right. It is. But in any workers' comp claim I've ever handled, there's 4 words with C that come into play, and you got to apply them in everywhere, which is consistency, corroboration, communication, and that leads to the credibility. So it's not going to be that someone's going to go up to one doctor and say, oh, I have ringing in my ears. Whether I'm representing the injured worker or when I used to do defense work, you got to go back and get all the medical records from all the different providers and see if there's a consistency of where they have these complaints, whether it's ringing in their ears or whether it's pain or whether it's headaches or anything else that might be just merely objective. So there's a way in which you can try to corroborate this over a period of time with many different sources. So beyond that, it's a Me Too from the Maryland Association for Justice.
All right. Go ahead, sir. These are favorable with amendments going forward.
Good afternoon, Mr. Vice Chair, members of the committee. Milton Nagel on behalf of the Maryland Association of Boards of Education Workers' Compensation Fund. We represent 17 of the 24 school districts here in Maryland, approximately 40,000 employees and a payroll a little north of $2 billion. Here respectfully to ask that the offset provision be struck from the bill. The 17 members collectively come together to provide self-insurance for workers' compensation, so the removal of the offset provision will result in a direct increase in costs back to the member boards of education, and already constrained budgets associated with no doubt all of you know about all the budget constraints right now with Kerwin and everything else, and this would just add to that. So we respectfully request that provision to be seriously looked at removing. Thank you.
Thank you, Mr. Chairman, members of the committee. Bill Kress here today on behalf of MABE's Workers' Compensation Fund. As you heard, there are 17 schools that collectively self-insure for workers' compensation purposes. So this bill is much more than about hearing loss, especially for the school systems. This bill essentially, and I don't think it's the intent, but it's a Trojan horse to open up claims after an employee has received accidental disability pension. So since the 70s, this body and the state of Maryland has said to government employers, if you have someone who's injured and has workers' compensation injuries, but then decides to take accidental disability retirement, you get to offset. You don't have to pay twice. In the case of the firefighter Spivak, he had $1,800 coming in from a pension. I think he would have maxed out at $1,200 under workers' comp, so he got the $1,800. So if you pass this legislation, it would be malpractice for a claims attorney to ever bring an occupational disease claim at the same time you're seeking disability benefits from a pension. You get the pension benefits if this bill passes, you wait a year or 2 years. Occupational disease are slow and insidious in development. They only are compensable, as you've heard, through disablement. So you can come back in and get compensation for that. You can get it for hypertension, heart disease, prostate cancer, carpal tunnel, you name the occupational disease, and after you get the disability benefits from your pension, you can come back in and get a second bite of the apple. That's double dipping. This body has always said, at least since the 1970s, that that's not appropriate. So we would ask that you strike that provision with respect to the offset. Thank you.
Seeing no questions, that concludes this panel. We will now go to the unfavorable. Lindsay Menninger, Edgar Dodd, Angelica Bailey, Carmen D'Alessandro, Ashley Smith.
Good afternoon once again, Mr. Vice Chair, members of the committee. For the record, Carmine D'Alessandro for the Chesapeake Employers Insurance Company Injured Workers Insurance Fund. We are here to respectfully oppose House Bill 590. I'm going to concentrate on the retirement offset. I agree with what Mr. Kress said in the panel before me as to offsets. Prior to Spivak, and I fully understand that the proponents are trying to address a Montgomery County issue that arose in a Montgomery County case. Unfortunately, the bill is spilling over and affecting retirement offsets that affect state workers and other municipalities. Prior to Spivak, there was an offset if an injured worker had basically overlapping disability payments, meaning you got into a car accident that was work-related and you were receiving workers' compensation benefits for your back injury. But you then retired on disability retirement for degenerative conditions to your back. Not the same incident, but the same body part. And the Court of Appeals in Rieger versus Washington County Board of Education and Sacagawea versus Baltimore County Board of Education indicated that there is an offset if the body parts overlap. This bill goes even further than that and says there's only an offset if the disability retirement and the workers' compensation benefits arise from the same accident. So it would eliminate 70% of the offsets that Chesapeake and the state of Maryland are currently taking. We simply want there to be overlapping body parts We agree that there are some problems with SPVAC, and we will look at the language. We want to revert back to the law in Rieger and Sacagawea. And so for those reasons and reasons that will be expressed after me, I respectfully oppose the bill and ask for an unfavorable report.
Lindsay Beidel-Menninger, again with Chesapeake Employers Insurance and the Injured Workers Insurance Fund. Just a note for offsets for the state of Maryland, accidental disability retirement. So if you have one accident and you retire because of that accident, the state takes the offset. The Maryland State Retirement Board takes the offset under State Personnel and Pensions 29118. Ordinary disability retirements for our state of Maryland employees are the offsets taken under 9610. Those offsets or ordinary disability retirements are for multiple injuries, multiple accidents, or a combination of both. So that is why the ODR, or ordinary disability retirement, is so important under 9610. And I will talk about math when you all are ready. I love it.
Good afternoon, Mr. Chair. My name is Edgar Dodd. I am the director of the Maryland Subsequent Injury Fund. I want to start by saying that our respect and appreciation for first responders is beyond measure. They are the best of us. And when they are injured, they are entitled to all benefits to which they are entitled. My opposition to this bill is strictly the adverse fiscal effect it will have on the Maryland Subsequent Injury Fund. Specifically, the consequence of eliminating the current accidental disability offset provision that the Subsequent Injury Fund currently enjoys. It may create a situation where an injured first responder, a severe injury, is awarded a disability retirement from the Maryland State Retirement System, and then they get a permanent total disability award from the Workers' Compensation Commission that includes Subsequent Injury Fund lifetime liability. The combination of those two benefits will exceed the salary that individual was drawing prior to the accident. We recently completed, or had completed, an actuarial study that showed the current 6.5% assessment funding mechanism for the Subsequent Injury Fund was adequate for the foreseeable future. That was prior to this bill. If this bill passes, that will have to be revisited. And any increase in the 6.5% assessment is something that we do not want to initiate. We do not look forward to. It will increase the cost of doing business in Maryland. And for that reason, we respectfully request an unfavorable committee recommendation on this bill. Now, I want to conclude by saying we understand some compromised conversations are taking place. We need to see the language of those compromise, and if in fact it meets our objections, then we'll be satisfied. Thank you.
Hello, my name is Ashley Smith. I'm here on behalf of the Maryland Defense Council. I just want to reiterate again what Mr. Dodd and Ms. Menninger are indicating, which is that we are seeking to avoid duplicative benefits. We are not seeking to prevent injured workers from receiving benefits, but we want to prevent duplicative benefits, and that is why the offset exists. Thank you.
Good afternoon, everyone. Angelica Bailey-Thupari with the Maryland Municipal League. It has been a long afternoon. It is warm, and this stuff is kind of squeaky. So if you'll bear with me for a moment, I just want to be very clear and very straightforward and break it down for a minute. Currently, workers' comp payments to employees are limited when they're already receiving disability. If the workers' comp payment is higher than the disability payment, the employer pays the difference. Cool. This bill eliminates that. So instead of paying the difference, local governments would have to pay the workers' comp for someone who's already receiving disability. Our understanding is that this bill as drafted is not narrowed to occupational deafness. It would allow a full double payment for all workers' comp claims. And because it would be so prohibitively expensive for your towns and cities, we are respectfully requesting an unfavorable report. Thank you.
It is pretty warm in here. And Mr. D'Alessandro, I just want to thank you for your explanation. I think that was the first time it was clearly broken out for me. So thank you.
Thank you.
Seeing no questions. Oh, sorry. Delegate Sample Hughes.
Chairman, and it'll be really brief. Mr. Dodd, you had indicated that the 6.5% was already assessed and now is seen to be adequate at our current status?
That is correct, based on the most recent actuary study.
And that's what I wanted to know. So
Yes.
when was the most recent actuarial study?
It was completed in January of '22.
Okay, and how frequently does that happen? Because I know you said that it would be an issue if we were, if this bill were to pass, that it would be an issue and it could be, you know, something that you didn't want to deal with.
Well, historically, we have been on a 5 to 6 year cycle. We are adjusting that to 4 years,
Okay, so the next time it would come up,
2026.
26. Okay, all right, thank you. Thank you, Mr. Chairman.
Delegate Harrison.
The biggest concern is monetary for you all, or for this panel, I should say. But someone who has pretty much, you know, given their career to run towards danger, to take care of all of us, and they have multiple injuries that may not occur at the same time. Or I should say, they may come up at different times. They're not worth, and so they no longer have a quality of life that you and I are now having. So they're not worth the being compensated appropriately.
Delegate, thank you very much for that very important question. You'll never hear local governments say that we don't value our employees, especially those that put themselves in precarious situations. And my dad has Meniere's disease, which includes vertigo, tinnitus, hearing loss. I can't tell you how many times we've been to the hospital and doctor's appointments over the years. I completely understand, and our members completely understand. The problem is financial, as you mentioned, and occupational deafness is not limited to those who run in first. We could be looking at Parks and Rec employees who work at a place like Glen Echo. We could be looking at fire and police, sure, but maybe construction folks as well. So it's not necessarily limited to occupational deafness caused by a high trauma kind of employment.
But it's,
May I respond?
well, actually, well, I don't know. So I understand that there are other individuals with occupational deafness, but people have, you know, through the course of their work, and maybe it's not a first responder, but through the course of their work, they've received multiple injuries that may occur at different times, and why are they not worthy of being compensated for that?
Thank you, Delegate. I would just answer briefly. To the extent that the injured worker is receiving total disability retirement benefits, they are being compensated for everything that affects them that arises out of work and their inability to participate in work. What we're saying is that they shouldn't be paid twice for that.
All right, thank you. No more questions.
All right, seeing no further questions, that concludes this panel and the bill hearing. Next, we'll go to Delegate Queen, House Bill 832. Oh, I'm sorry. We have one, no, the panel's still concluded. Does not conclude the bill hearing. We have one virtual, Brianna January. My bad. Well, eventually, we'll get to you, Pam. I'm so sorry.
No worries, Mr. Chair, Mr. Vice Chair, esteemed committee. Brianna January again with MACO in respectful opposition to HB 590. So sorry that I cannot be there in person with my colleagues, but my broken foot has basically pinned me to my house for the next few weeks. Counties do have several major concerns with this bill, which are outlined in my written testimony, and they mainly do relate to those offset issues that have already been expressed by my colleagues and the unfairly duplication of benefits under them. My written testimony details what this would mean specifically for counties as major employers in the state. And committee, I just also encourage you to please read the fiscal note as it does further detail and affirm some of those concerns. That said, I'd like to thank the delegate for his willingness to work with us, and we do look forward to seeing those amendments that he alluded to. But as drafted, MACO requests an unfavorable report. Thank you.
Okay, seeing no questions, that concludes this panel, and I promise that concludes this bill hearing. Next, Delegate Queen, House Bill HB 832.
Does this mean I get a pass favorable? That's not nice. All right, thank you so much. This has been a hot afternoon, but I learned a lot. I don't know if you all learned a lot from this hearing. Okay, well, Mr. Chairman, members of the Economic Matters Committee, For the record, I'm Delegate Pam Queen, and I'm presenting HB 832, Labor and Employment, Equal Pay for Equal Work Wage Transparency. So I would just like to just talk about this bill and why we think it's needed. I come from a family of folks who served in the military, those who are like skilled laborers with the union, folks who work for the federal government and with the GS schedule. And so to my surprise, when I first graduated from college and got the first job in private industry, you know, I thought it was a great thing that I was making $4,000 a year more than what the comparable GS7 schedule will be for that job. And to my chagrin, I would learn that of a cohort of 30 persons who were all new hires, new first-time people being hired to the job, no prior work experience. I was one of 2 females and the only African-American of this 30-person cohort. I learned that there were people making $10,000 upwards to $20,000 more than that comparable GS7 schedule. Now, mind you, the person who was making $20,000 more was a graduate of MIT and had a master's degree. But nevertheless, we were all new college graduates, no college experience, no work experience, doing the same work, and that was a wide disparity in the pay raise. And that was a gap that for years would haunt me. It's hard to catch up over a $10,000 to $20,000 gap in salary. I tried to do it with getting master's degrees and actually have 2 master's degrees and a PhD, but I still make less than people, white males who have my same background. And to me, that's not fair. I don't know who would think that's fair. I don't know what rationale we would say that makes sense for employers not to give a job a pay raise. If this is the job you want someone to do, why can't you tell them this job pays between A to B? If I don't want that job because it pays between A to B, then I'll look someplace else. You don't just willy-nilly pay somebody else more than A to B just because you like them, just because they interviewed well. The job is the job, and the skills are the skills, and we should know what they are. So this is just asking something that we think is fair, that we should be doing already in Maryland law. If someone you're interviewing with asks for the pay range, you can tell them that. So why can't you put it on paper when you put out the job description? That's all we ask for, and we look for a favorable recommendation on this change. Thank you.
Great. Thank you, Vice Chair Crosby, members of the committee. My name is Callie Shumitz. I'm with the Maryland Center on Economic Policy, and thank you to Delegate Queen for introducing this bill. We're here in strong support of House Bill 832 because we believe that your pay should be based on your job duties and your experience, not external factors like your gender and race. We appreciate this committee's past commitment to this principle. House Bill 832 will build on the salary history legislation you all passed in 2020 and Maryland's equal pay for equal work law passed a few years earlier. Including pay ranges and job announcements is a really simple step that can help close disparities in pay for women and people of color. As Delegate Queen did a great job of explaining, there are multiple reasons for pay disparities, but House Bill 832 will address an important one by leveling the playing field in salary negotiations. Right now, women in Maryland are paid 86 cents for every dollar paid to men, and that gap is even greater for Black, Hispanic, Asian, and Native American women. For example, Latina women earn 46 cents for every dollar a white non-Hispanic man makes. Research shows that women tend to ask for less pay than men with similar skills and experience during the salary negotiation process. And as women are more likely to be underpaid in the role they are leaving, they will also tend to ask for lower pay when moving to a new job. However, research also shows that when job applicants are clearly informed about the context of negotiations, like the range the employer is able to pay, these gender differences in negotiation outcomes lessen, and which could help narrow gender and racial wage gaps. When people are paid less fairly, they're less able to provide for their families. So we think eliminating secrecy around pay is an important step forward for racial, economic, and gender justice in the workplace. So I'd ask for a favorable report on House Bill 832. Thank you. Andrea, next.
Sure.
Okay.
Hello, thanks to the committee for having me here today. My name is Aaron Sayedian. I'm the founder of Well Paid Maids. We're a home cleaning company based out of Tacoma Park, been in business since 2017, and employ around 30 people. My company supports this bill. I support this bill as a Maryland small business owner. I believe it's the right thing to do for workers and job seekers. In addition, we happen to already do this. All job opportunities at Well Paid Maids are announced with the starting pay included, and I can't imagine operating any other way. I also can't imagine why being required to do this would be a big deal for any other business. If we didn't do this, we would basically just waste time reviewing applications and engaging with candidates who wouldn't consider working for what we pay anyway. And because we're so upfront about our compensation, I know that we can review our applicants for, are they a good fit? Are they qualified? Not, is it an affordability issue, right? So this way we spend less time hiring and have better outcomes and better retention. And it's important as a small business too, because there's no HR team. It's me and my partners. And so that time and cost savings is crucial. We also appreciate that the law requires employers to include in a job announcement a general description of benefits and other compensation in addition to the pay range. That's important because we have a total compensation package. So in addition to our starting wage, $22 an hour, we offer comprehensive benefits, and the details are important. And the job interview is the right time to discuss them before somebody commits. Every job seeker should know that information ahead of time so they don't miss that crucial opportunity to ask questions. Finally, from a workforce development and modernization standpoint, I think this bill is beneficial. Our society encourages people to educate and train so they have access to job opportunities. But if employers, aren't transparent about what they pay, Marylanders will be held back in their efforts to move into higher paying jobs and know where those jobs are. In fact, in one study, pay transparency shifted education choices, especially among poor students, leading them to major in fields with higher economic return. And for those already in the workforce, posting the pay ranges helps them get good info. So basically the status quo just creates additional friction. Let's get rid of it. I urge a favorable report. Thank you.
Good afternoon, committee. My name is Rebecca Snyder. I am the Executive Director of Executive Alliance, and we are a professional women's organization dedicated to creating opportunities for professional women in Maryland's boardrooms and executive leadership levels. We sit in support of House Bill 832. Aaron talked about his personal experience on why this bill is important to businesses like his, and I just wanted to broaden it a little bit. You've heard from various panelists about how this will affect women, people of color, but it also benefits businesses. This is one of those unique bills where everyone benefits, and we feel like it helps, that clarity and transparency helps retain and attract employees and creates a system of trust so that, as Aaron was saying, you can focus on the job at hand as opposed to trying to hide, well, maybe this doesn't pay what one would want, or you get to talk about the whole total compensation. Candidates are seeking out this information. By 2025, 75% of the workforce will be millennial, and that is a generation that is very open about financial status. They want to know what wages are. They're not afraid to talk about it, and employers are going to be caught with the short end of the stick if they don't sort of lean into that transparency. Finally, it also allows a company to, in this really tight labor market, it allows an employer to commit to equality and fairness and really live their values. DEIB has been a huge buzzword for the past couple years, but this is a very real and tangible way for employers to walk that talk in a way that benefits them and benefits their potential employee pool. We do know that some amendments have been offered, and we also want this to work for businesses. So we are committed to working through that, and we urge a favorable report. Thank you.
Thank you, Vice Chair. Andrea Johnson. I'm here as a resident of Silver Spring, Maryland, and on behalf of the National Women's Law Center in support of HB 832. The Law Center has been working with closely with state policymakers across the country on this type of legislation, and we are really seeing laws like HB 832 that would require employers to put the pay range in the job announcement take off all across the country, in part because of how effective it is at closing racial and gender wage gaps, but really in large part because employers and lawmakers are seeing how sharing pay ranges helps businesses attract talent and save costs and time in hiring. And my written testimony cites all of those things, how there's actual remarkable diminishing of costs in hiring. And that gives businesses in their state a competitive edge. So this is an exciting bill in that respect. We've heard from businesses, more and more businesses over the years, that small and large businesses alike, the pay range transparency helps them more efficiently and effectively find a match with candidates. And the time and cost savings are particularly important for small businesses without an HR team. It helps give them an edge. And we've really seen survey after survey over the last year showing that an overwhelming majority of applicants are more likely to apply for a job if the pay range is in the job announcement, and a lot would not even apply for a job that doesn't include the pay range. And that's becoming increasingly true with Generation Z. The most recent study I saw showed that 85% of Gen Zers would not apply for a job if it doesn't include the pay range. So this is where we're heading, and we don't want Maryland to lose out. And Maryland already has a law that requires an employer to give the pay range if asked, but businesses aren't getting that recruiting edge that you get when you put the pay range in the job announcement. So that would change that, and also increase accountability for closing wage gaps. And it's not surprising to us that businesses are so excited about this. It's not surprising to us that Colorado, the first state to pass this kind of pay range transparency law, saw businesses complying with the new law at high rates right out of the gate. I was just speaking with some Colorado advocates and enforcement folks, and they said this is a simple measure. Just be transparent about what generally you're hoping to pay for a position, the minimum, and what you're willing to pay, the maximum. And it's easy to comply with and enforce for them.
Quick question before we take it. Everybody else, does this law mirror what's in Colorado?
It is actually simpler than what's in Colorado insofar as it doesn't include a whole piece that Colorado includes about having to advertise promotions, et cetera, promotion opportunities. This is just about putting the pay range in the job announcement.
Okay, Delegate Charkoudian.
Thank you, Mr. Chair. Thank you for bringing this bill. I think we have seen where transparency about pay really is a key piece of addressing pay gaps. So I really appreciate bringing this bill, and to everyone who is testifying on it. And Aaron, I had a question for you, and welcome, coming from my home district. You talked about one of the things that I'm seeing in the opposition is how burdensome and complicated this is for folks who don't have an HR department. And you mentioned that really quickly. So I just wonder if you can talk about the size of your business, the lack of HR department, and what exactly you see this bill meaning and how you do it without it being burdensome to your business.
Yeah, sure. So, when I was mentioning how we don't have an HR department, that was in reference to any amount of time that we can save in recruiting and hiring is a good savings for us, because there's a tremendous amount of churn that goes along with finding the right candidate, and not having a dedicated person who wakes up every day and does recruiting means that, if we can shave a back and forth that was based on someone not knowing the pay as they start as an employee and us having to tell them, and that being, a deal breaker or whatever, that saves us time. But to the rest of your question in terms of, maybe what some folks are seeing in this bill that they don't like, I understand it's around like compliance and record keeping. So we don't have HR, and reading this bill, it doesn't seem onerous to me insofar as, depending on what job platform you use, and let's be honest, like all of this is digital now, a record is automatically created every time you put out a job listing. And so by default, employers have a record of all of their job announcements. And in the same token, as they offer people jobs, restating what was said in the interview, et cetera, the archive of emails forms another record. So I don't think there's any additional record keeping task that goes along with this. And so I'm not daunted by that aspect of it.
Thank you. Thank you, Mr. Chair.
Delegate Rose.
Thank you, Mr. Chair. So in the bill itself, it's also applying, if you are a small company and you don't have an HR staff and you don't have a recruiter, often they will use a staffing agency. So I would like to know about the liability if you reach out to an outside staffing service and they violate the letter of the law, who is going to pay the fine? Who is going to be held responsible? Is it going to be the staffing agency, or is it going to be the employer who didn't post the job in the first place if they are using an outside service? So can you address that?
I can speak to that. So just looking at the bill language, it speaks, the way it was drafted, it speaks of both the employer and the employment agency having an obligation to include the pay range. But I think any penalty would be on the employer. And I will say that we've seen different states take different approaches. Some just require put the liability and any penalty on the employer. The employer would need to make sure, when they're giving it to a third-party agency, that they're also including the range. Some put liability on the employment agency. So I think there's a policy decision to be made there. But usually I think employment agencies are getting this information from the employer who has that obligation to provide that information. So that would be an approach to put the onus on the employer.
I mean, I can look at that, but, prior to going to academia, I've been a hiring manager, and we work with third parties to reach more people. And you can't post anything unless I agree to it before then. So as the hiring manager of that employer, that agency that's helping me recruit would not be putting anything out that I didn't approve. So I would know it.
I think that makes sense in theory, but I know that there's a lot of small businesses who are so busy doing their business, they rely on the staffing agency. So I think it's a big concern with the way that the bill is written, that unbeknownst to an employer, if the staffing company makes a mistake, you could be held liable to a very high degree.
Well, let's check with the legal on that, because again, I would think that would be something, you would work between the staffing agencies. The staffing agency would probably have to have some sort of warranty and bonding kind of things if I brought a suit against them. So we can look at that.
And then just one follow-up. Okay, and then the other issue, working in that industry myself, I've seen where when we do actually already voluntarily put the salary range. It's a competitive job market. We advertise benefits, we advertise a lot of things. How would this bill affect the flexibility of an employer while maybe not necessarily planning to at the start, after finding out how difficult it is to hire a qualified employee, the flexibility of then deciding to provide a sign-on bonus maybe for just somebody that's a great candidate? If the other employees find out about that, or other applicants, are you going to be held liable because you didn't offer that sign-on bonus to
I don't think so.
these 10 people, but you are to this person that you
I
hired?
don't think so. I don't think that impacts that, but
No, so
we can
this
make
is,
that clear.
thank you for raising that question. And this is just a transparency requirement to say a good faith estimate of what you expect to pay for the position. Put that out there. You're not obligated to pay within the range that you put out there. Circumstances might change, and so we want to make sure that employers have that flexibility. So there's still that flexibility, and if you pay outside the range, this bill would not have any sort of liability on you incurring because of that.
Thank you.
Okay, seeing no further questions, that concludes this panel. Happy AKA or Founders Day, Delegate. Now we have two more favorable, Joe Zarafa and Rebecca Snyder. Oh, I'm sorry.
I believe it's me, Vice Chair Diana Jarrett, on
It
behalf
is.
of the Public Justice Center.
Yep, you're right.
Wonderful.
Go ahead when ready.
Wonderful. Good afternoon, everybody. Diana Jarrett on behalf of the Public Justice Center, where I work as an attorney for the Workplace Justice Project, which advocates for low-wage workers to receive an honest day's pay for an honest day's work. The Public Justice Center strongly supports this bill, which is a common-sense bill requiring employers to post pay ranges in their job announcements. As my previous panelists stated, workers overwhelmingly support pay range transparency in their job postings. In fact, some studies show up to 98% of workers believe that employers should disclose salary ranges in job postings because understandably they want to know upfront what they can expect to be paid for a job that they're applying for. Importantly, adding pay ranges to job announcements is a matter of gender and racial equity, as this simple addition has been shown to close the wage gap for women and people of color. The wage gap translates into an annual median loss of approximately $24,000 for Black women and $29,000 for Latino women in Maryland. This lack of pay transparency directly perpetuates pay disparity and keeps working women of color in poverty. I echo the testimony of my fellow panelists that salary range transparency also helps employers attract and retain talent while saving everybody time and money throughout the hiring process. Currently, about 30 million workers in the United States are now entitled to pay range transparency when applying for a job, and we at the Public Justice Center believe that Maryland workers also deserve this upfront pay range transparency. And for those reasons, the Public Justice Center requests a favorable report on HB 832. Thank you.
Okay, seeing no questions, is Joe Zarafa here?
Yes.
Go ahead, sir.
I'm also here to support in favor of this bill. I work for a company that voluntarily posts their pay ranges, and one thing I want to address was the comment about sign-on bonuses. My company offers sign-on bonuses currently. They straight up say that in the job posting of we will offer a sign-on bonus. They don't disclose that, but they will disclose the salary pay range for our base salary compensation on there. It's fantastic having that. I can know if I am equally paid for my role. And then also when I've been looking for roles in the past, my first question to a recruiter, if it's not posted, is what is the pay range? They instantly come back with it. It saves me some time of that back and forth that was mentioned earlier. And these companies already know what they're willing to offer people. It's just a matter of them posting out there so applicants can see it while they're looking for jobs. Thank you.
Thank you. Seeing no questions, that concludes favorable witnesses. We have one unfavorable, Sarah Price.
Good afternoon, Mr. Chair and honorable members of the committee. My name is Sarah Price, here on behalf of the Maryland Retailers Association in respectful opposition to this proposal. We do feel that it would be unnecessary and the record keeping could be potentially burdensome for our industry. The current equal pay law in Maryland is incredibly effective. And unless I've been misinformed, the Department of Labor has not received any complaints about that law to this point. We are in a very tight labor market right now. There is no reason that a business would alienate itself against potential employees by not sharing pertinent information about jobs. We really don't think that this is an issue. As the previous panel noted, applicants are fully capable of requesting this information and they can turn down a job if they don't want it. As far as record keeping goes, we do believe that this could be burdensome for our industry, given that many retailers can receive hundreds of applicants throughout the year. Warehousing, I know, employs an additional hundreds and hundreds of employees during peak hours around the holidays. And while, yes, a record may be generated by each job posting online or by an applicant submitting something, the method of having to keep track of every single one of those to potentially respond to a complaint could be very untenable for a business. We also have additional concerns about the lack of definition of job posting in the bill. We've all seen businesses posting help wanted signs in their windows. The bowling alley on Ritchie Highway has a sign up right now that they're hiring for snack bar employees. Royal Farms has signs up all the time by the side of the road. I've seen posts from the Office of the Comptroller on Facebook about job postings. All of these are typically very brief, quick postings, and we wouldn't want anyone to be precluded from advertising in this way based on the requirements in this bill. So we would urge unfavorable. Thank you.
Thank you. Delegate Boifo.
Yeah, really quick. Thank you for being here. You talked a little bit about record keeping being burdensome. You're from the retailers, correct?
Yes.
So we're talking about, some of your members having, thousands and thousands of inventory, supply chain. Talk to me about how this is different in comparison to some of the great record keeping you guys are doing currently to have stuff on the shelf, et cetera, et cetera.
So I think the concern is about the record keeping in conjunction with being found not in violation. Like if an applicant 3 year, up to 3 years after applying or 3 years after maybe discovering that a listing was non-compliant, which, when I'm applying for jobs, I'm keeping a spreadsheet of, every position that I'm applying to, what the job listing says. I might have a link to the job listing or a screenshot of it. So let's say more than 3 years after someone applies for something, they could be going back through their own records and find, oh, this listing didn't include the wage range. Maybe other people were impacted by this. Maybe we could get, a class action together. That's some of the concern here, is being able to respond to larger complaints like that. And if you do have a warehouse that's receiving, 2,000 applicants in October or November, that's a lot of people to keep track of, just to be able to pull from quickly. Or frankly, retail and restaurants, other aspects of the service industry are pretty simple positions to send out a lot of applications for if you are trying to meet your unemployment requirements. So you may have people who are applying and then not showing up for an interview, whether they've taken another position in the meantime, or they just were, hey, I have to show that I'm applying. I mean, they are looking for work, obviously. But there's just, given that the industry has so many applicants, typically, that it could be difficult to keep track.
Delegate Rose.
Thank you, Mr. Chair. So going back to the record keeping, so when you're talking about, it's one thing a Walmart keeping track and having, a sophisticated applicant tracking system that you own, you pay for, and you have those records. A lot of the smaller businesses, wouldn't it be true that they would maybe take out, instead of having an Indeed account, which is very costly, would maybe just do a single job posting, or maybe 2 or 3 a year, but you don't have an actual account, and if you're small, you don't have an applicant tracking system, which are thousands and thousands of dollars.
Right.
Wouldn't that make the burden of record keeping in those situations particularly onerous on the smallest businesses?
It absolutely could. And I've worked at chain restaurants that I've filled out a paper application within the last decade, so not everything is online these days.
Thank you.
Delegate Harrison.
Thank you. So I'm still on the record keeping piece, and the text says that each employer shall keep a record of compliance for each job, promotion, transfer, or other employment opportunity. Is it then your concern about the promotion, transfer, or perhaps other job opportunity as opposed to the posting of the job?
It's all of it, frankly.
So a restaurant perhaps may, your retailer, so H&M may put out, may have a job opportunity for a manager. How often does that occur so that it would be so many postings? Because the way that I'm reading this, and I could be reading it wrong, is that you have to show that you've been in compliance for the job, and I'm reading that as the job posting. So how many could there possibly be that it could be that difficult? I can understand perhaps the promotion, the transfer, but for the job, and if it is that hard, would you be opposed to removing promotion, transfer, or other opportunity? Because I think the whole thing, and I'm sorry, I'm going to let you answer. The whole thing is that if I know that your job only pays $20,000 and I know that I need to have $45,000, I'm not going to bother applying to your job. And therefore, you don't have to even bother looking at my application. Does that make sense what I'm saying?
It does, I think, and I think it would be helpful to narrow it specifically to new job postings. Most people are asking ahead of time, so that does, nothing stops an applicant from, or someone seeking employment from seeing a job posting, seeing that it doesn't list a range, and then calling that business and saying, hey, I saw this. Can you tell me what it pays before I bother to submit
Does
something?
that really happen, though? I don't know. It's been a long time. Maybe Delegate Fisher will offer me a job, and I can ask him what the pay range is. But
I think it depends on every
I'm asking
business.
because I honestly don't know. Do people really do that?
I mean, they may. Nothing's. I would say yes. I don't have specific experience with every single business with doing that. I mean, I know my mom always tells me, go out and hit the bricks. You need to go in and talk to businesses, but I think we can all acknowledge that that's a bit dated advice.
Hey, watch it. All right, thank you.
All right, thank you. Seeing no further questions, that concludes this bill hearing and bill hearings for the day. I just want to thank all the members. It is extraordinarily hot in here, so I appreciate you all hanging in here. Have a good night.